ಇದೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಅದು. Then ನಾನು
2014 ಫೈಲ್ ಆಗಿದೆ.
ನಂಬರ್ ಕೊಟ್ಟಿದ್ದು ಪ್ರಿಂಟ್ ಅಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದು ಪೇಂಟ್ ನಾ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ಸಾರಿ, ನಾನು ಲಾಸ್ಟ್ ಡೇಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತಲೇ ಅವ್ರು ಹರ್ಷವರ್ಧನ್ ಮಾಲಿಪಟ್ಲಿ ಹೇಳಿದ್ರು ಅಂತ ಆನ್ ದಟ್ ಬೇಸಿಸ್ ಐ ಆಮ್ ಸಬ್ಮಿಟಿಂಗ್. ನಾನು ಲಾಸ್ಟ್ ಡೇಟ್ ಇರ್ಲಿಲ್ಲ. ಇಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಲಾರ್ಡ್ ಹಿಯರಿಂಗ್ ಇಟ್ ಬಿ ಟೇಕನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೈ ಲಾರ್ಡ್, ಐ ವಿಲ್ ಗೆಟ್ ದ ಫೈಲ್ ಅಂಡ್ ಆರ್ಗ್ ನೆಕ್ಸ್ಟ್ ಬುಧವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ. ಸರಿ serial number 47, my lord. I will take the details from Manvinder Reddy and I will bring the LRs connected matter. ಅದು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ 47 ಅವರು ಒಂದು ಹಾಕಿದ್ದಾರೆ. KIDB ಒಂದು ಅಪೀಲ್ ಇದೆ. ಅವ್ರು LRs ತರ್ಬೇಕು. ಅವ್ರದ ಹತ್ರ ಡೀಟೇಲ್ಸ್ ತಗೊಂಡು ಐ ವಿಲ್ ರೆಕ್ಟಿಫೈ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
Time.
Any other update? Isn't it? We will see.
Please.
Yes.
Pronouncement of judgment, CL number 1, Villappa Yadu.
I think on behalf of Philip. Appeal is dismissed. Draw declared. Yes. Yes.
Non-compliance of office objection for first time, CL number 2, SS Alalli.
See, ಅರ್ಧ ಕನ್ನಡ ಅರ್ಧ ಇಂಗ್ಲಿಷ್ ಇದೆ, ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು ಹಾಫ್ ಈಸ್ ಇನ್ ಕನ್ನಡ, ಹಾಫ್ ಇಸ್ ಕಾಪಿ ಕಳಿಸ್ತಾರ. ಇಲ್ಲ, ಹಾ, ಇದನ್ನ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಯಾಕೆ ಇಲ್ಲ ಅಂದ್ರೆ ಇದನ್ನ ನೈದರ್ ಸಿ ಮಿಲಾಡ್ ಪೇಜ್ ಹಾಫ್ ಕನ್ನಡ ಇದೆ, ಹಾಫ್ ಇದೆ.
Officer objection at serial number 3 is overruled.
57.
List is ಏನು
not the compliance of the order, directed the immediate to take steps to issue an appointment order. This is in regard with the issue of appointment order. Page 56 is the division bench order. In the last para, it is needless to mention that respondent 6 shall take immediate steps for issuing an appointment order to the respondent number 9 and also comply with the directions issued by them.
Learned government advocate takes notice for respondent number 1. Issue notice to response number 2 and 3, returnable by (25th of November).
Yes.
Please.
Learned counsel for the complainant is directed to serve copies of the petition along with annexures on the learned government advocate.
Complaints of office objections for fifth time. Serial number 3, additional
Lord,
comment.
Serial number 3 and 4, my lord. Finally, your lordship grant 2 weeks time, my lord, compliance.
Serial number 4, I have got a submission. In this case, the respondent compulsory retirement order was set aside by the Karnataka Administrative Tribunal. Thereafter, I gave a representation. They say that the matter is pending before the Honorable High Court ಅಂತ ಹೇಳಿ ನನಗೆ ಜಾಬ್ ಮೇಲೆ ತಗೊಳಕತ್ತಿಲ್ಲ. ಈಗ 6.5 ತಿಂಗಳು ಉಳಿದಿದೆ. 2023 ಇಂದ ಅವ್ರದ್ದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೇ ಬರ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಆಫೀಸ್ದವ್ರು ಹೇಳ್ತಾರೆ. ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸೆಟ್ ಅಸೈಡ್ ಬೈ ದಿ
Contempt petition.
ಅಲ್ಲಿ ಕೂಡ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಹಾಕಿ ಮೆಮೊರಂಡಮ್ ಹಾಕಿ ಅಲ್ಲಿನೂ ಒಂದು ಆರ್ಡರ್ ತಗೊಂಡಿದೀವಿ KAT ಅಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಗಿವನ್. ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಕೂಡ ಪರ್ಸೂ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಬಟ್ ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ದೇ ಸೇ ದಟ್ ದ ಮ್ಯಾಟರ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದ ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ.
Serial number 3 ಅಲ್ಲಿ
4 ಸರ್, ಸಾರಿ.
Serial number 3. Finally, at the request of learned government advocate, a week's time is granted.
2 weeks time,
2 weeks time is granted for complaints of office objections.
please.
ಅದ್ ಕೊಡ್ರಿ, 4 ಕೊಡ್ರಿ.
Number 4.
Office objection at serial number 5 is overruled. Finally, a week's time is granted at the request of learned government advocate for complaints of office objections raised at serial number 4. It is only regarding attested true copy. ಅದ್ರಲ್ಲಿ seal ಹಾಕಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ.
Please, Lord, I will get it. I'll do it.
Release this matter. List this matter for preliminary hearing on 19th of November.
Please.
Serial number 5, Nagaraj Patil.
The matter becomes infructuous, my lord. Infructuous ಆಗಿದೆ.
Okay,
Please, my lord.
ಕೊಡಿ. Yeah,
ಇಲ್ಲ ಆರ್ಡರ್ ರಿವೋಕ್ ಮಾಡಿದ್ದಾರೆ.
ಕೊಡಿ ಅವ್ರ ಪೇಪರ್ ಕೊಡಿ. Learned counsel for the petitioner has filed a memo stating that the prayer made in the writ petition has become infructuous since the respondents have issued necessary orders.
ಅಲ್ಲ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ರಿವೋಕ್ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ
Please.
issued necessary orders revoking the order of suspension.
Yes.
Huh?
ಇಲ್ಲ ಆಲ್ರೆಡಿ ಬಿನ್ ರಿವೋಕ್ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ರೀ, that is why you are saying the prayer
Yes,
has
ma'am.
become infructuous.
Yes.
ಬರ್ಕೊಡಿ.
Please.
Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous.
Please.
Serial number 6. Kirangoda Mali Patil.
Only 1 week time. Weeks time. Court fee ಕಟ್ಟಿದೆ.
Fifth time
Yes,
for complaints.
yes.
Court fee is also not paid.
DD ಕಳಿಸಿದಾರೆ ಸ್ವಾಮಿ. 1 week ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ. Finally 1 week.
9 office objections are to be complained.
Yes. Finally 1 week.
Finally, a week's time is granted at the request of learned counsel for the appellant for complaints of office objections. Full stop. release this matter on 19th of November. Please, full stop. If office objections are not complied by the next date of hearing, the appeal will be dismissed.
Please.
Order CL number 7, Deepak V. Barad.
R1 has to comply, my lord. R1 filed the, my lord, writ appeal. There is a
Writ appeal,
non-compliance of office objections.
You know?
Lord, R1 has to comply the, my lord, order passed by the Supreme Court, my lord. He filed the appeal, my lord, that is connected matter.
Hmm.
There is a office objection raised by the office.
Annexure H, J, neat and legible copy, English translation. Office objections raised in the connected writ appeal or overruled.
My lords. Serial number 7.
Huh?
Lords, this connected matter, my lord, is pending before the apex court, my lord. I have filed a contempt petition for disobedience of the order passed by the learned single judge
Hmm.
for deemed
Writ appeal ಹಾಕಿದಾರಲ್ಲ ಈಗ.
that is pending, my lord, and another order which is connected, my lord, has been pending before the apex court. It is about to come on 22nd of this month itself, my lord. Since a change of land use and has been approved by the government, my lord. Subsequently, my lord, lords may kindly see the order at page 63 is in challenge before the apex court, my lord.
Which matter is before the Supreme Court?
My lords, page 63. The order passed by this honorable court is pending consideration, my lord. Since, my lord, the Urban Development Authority has preferred an SLP before the apex court, my lord.
65 Annexure K is the order of the learned single judge.
Yes.
Which is the order of the division bench.
My lord, page 63.
63 illa re.
Lords, may I take to
It is
annexure
something
J, my
else.
lord, J.
Annexure,
J. Lord, my contempt petition. Page 63. Yes. Lord, the learned single judge had ordered for considering my application for single layout, my lord. I had filed contempt petition. Thereafter, they preferred the writ appeal, my lord. My lords, this court, my lord, had ordered me to pay rupees 5 lakhs, my lord, as a cost.
Huh?
Rupees 5 lakhs as a cost, my lord, since.
ask for,
My lord, since, my lord, it was ex post facto permission, my lord. I had deposited the same, my lord, before this court, my lord, within the stipulated time as per the direction gives by this court. Page 73.
Hmm.
Thereafter, my lord, now the Urban Development Authority is in, has challenged this order before the apex court, my lord. In the meantime, my lord, I had filed a writ petition before this honorable court, seeking for deemed single layout plan, my lord. Since they had not considered my application since 2010, my lord, the learned single judge had ordered was deemed construction of deemed single layout plan. But my lord, since this order is in challenge before the apex court, it is posted on 22nd of this month itself. Lord, if that is decided either way, my lord, this will also be.
Time when I was sitting,
Yes,
these
Lord.
matters had come up. Is that-
My lords had imposed a cost of 1 lakh rupees, my lord. Contempt of drop by this honorable court, my lord.
Ah,
And my lord, I had deposited the same amount within the stipulated time.
ah.
Thereafter, my lord, a NA was granted by the deputy commissioner.
Hmm.
My lord, there subsequently, my lord, a change of land is also granted by the government, my lord. The only question was remaining or approval of the single layout plan. My lord. That I had made an application before the authorities, my lord. That was not considered. Again, I approached the learned single judge. Learned single judge had ordered for considering my application for single layout plan. My lord. Subsequently, my lord, I had filed this contempt, my lord, page 83, 63, my lord. They had also filed a appeal against that order, my lord, learned single judge order. My lord, their appeal came to be dismissed and the contempt was also dropped. Again, a order was passed by this honorable court at page 74 that, my lord, my application for a single layout plan should be considered. My lord. That was not been done and they have preferred this order before SLP before the Supreme Court. My lord. Now it is pending consideration on 22nd itself of this month, my lord. Since, my lord, I had compounding charges I had deposited of NA also, my lord, 10 times of the normal charges. As the
You have filed SLP.
yes, sir.
Huh?
Yes, On 22nd, it is posted, my lord.
This
before-
appeal is filed on the ground that, my lord, admittedly, the application for the single layout, for approval of single layout plan was filed on 11/10/2021. The application should be filed along with all requisite documents. Here, my lord, that application was not accompanied with the, my lord, order of change of user of land. It was a residential residential reserved. The change of user of land was done on 29/3/23. From 29/3/23, if the mandatory period is taken, my lord, that is not correct. For only on that ground, this appeal is pending. Anyhow, matter is seized with the Supreme Court. My lord, the series of writ petitions and writ appeals, contempt ಎಲ್ಲ ಆಗಿದೆ. ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ on the basis, my lord, then this will reach a logical end. Here, my lord, that building was constructed without conversion, without permission, without change of user land. For all these reasons, my lord, he is facing all these troubles. And he is making the payments as per the cost imposed by this honorable court and as per the compound, my lord, the compound table, they have calculated. Penalty ಅದು ಏನಿದೆ ಅದು 27 ಲಕ್ಷ ಅದು ಕಟ್ಟಿದ್ದಾರೆ. But this matter is anyhow is in the Supreme Court, my lord.
For what?
But challenging the earlier order of this court. ಹಾಕಿದ್ರೆ
Alri,
ಇದೆ.
if there is any useful purpose that would serve, we can understand. This court itself has imposed costs and penalty and everything.
Yes, my lord, that's
You have
what I'm
collected
saying.
it.
ಏನಿಯೋ 22 ಇದೆ ಅವತ್ತು ಅವ್ರು ಏನ್ ಇದು ಮುಗಿಸ್ತಾರೆ ಅದು ಆದ್ಮೇಲೆ ಮುಗಿಸ್ತಾರೆ.
At the request of learned counsel for the complainant, release this matter
First week.
on 25th of November.
Please, my lord.
Yes.
Serial number 8, Ganesh Subhash Chandra Kalaburagi. Serial number 8.
I'm proxy counsel, my lord, appearing on behalf of appellant, my lords. It may be taken up tomorrow, my lords, and application for additional evidence is to be filed by affixing federal. It may be taken up tomorrow, my lords. Council is held up in court hall number 4, my lords.
Yeah, ಇದು ಓದ್ ಬಾರ ಬಂದಿತ್ತಲ್ಲ.
Hello.
This matter come up last week.
ಬಂದಿತ್ತು.
ಹಾ?
ಹಾ. 6ನೇ ತಾರೀಕು ಬಂದಿತ್ತು. Matter was heard.
Why is not here today?
My lords, the council is held up in court hall number 4, my lords, but
The party,
party, my lords,
tell the appellant.
I'm told that, my lords, his grandmother is not feeling well. So his grandmother is not feeling well. It may taken up tomorrow, my lords. He'll be present along with the application for additional evidence.
Both the parties are not present.
ಬಂದಿಲ್ಲ ಇವತ್ತು ಕೆಲಸ ಅಂತ ಲೇಟ್ ಈಸ್ ಕಮಿಂಗ್ ಲೇಟ್ ಬರ್ತಾ ಇದ್ದಂತ ಏನೋ ಕೆಲಸದಲ್ಲಿ ಇದ್ದಂತ ಬರ್ತಾ ಇದೆ ಕೂಲಿ ಕೆಲಸ ಮಾಡಿ
You are appearing with the husband. Huh?
ಯು ಆರ್ ಪ್ರೆಸೆಂಟ್ ಆನ್ ಲಾಸ್ಟ್ ಡೇ ಆಫ್ ಅಪಿಯರಿಂಗ್.
ಅದೇ both of them were present.
ಇಲ್ಲ ಇದ್ದಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಬಂದಿಲ್ಲ.
Huh?
ಅಪಲೆಂಟ್ ಬಂದಿದ್ದಿಲ್ಲ ಲಾಸ್ಟ್ ಡೇಟಿಗೆ.
But the respondent was present. Huh?
ಹೌದು ಬಂದಿತ್ತು.
ಅದೇ ಅದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ but she is
Yes.
saying no, not a marriage.
ಮ್ಯಾರೇಜ್ ಅದು.
ಹೌದು. Why is he not present today?
ಏನೋ ಡೈಲಿ ವೇಜಸ್ ಕೆಲಸ ಮಾಡ್ತಾನೆ ಸ್ವಲ್ಪ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡ್ಬರ್ತೀನಿ ಸ್ವಲ್ಪ ಸ್ವಾಮಿ ಅಂತ ನಾನು.
We can have it tomorrow.
Please.
Huh?
ನಾಳೆ
At the request of the learned counsel for the appellant, release this matter tomorrow.
Please, my lords. Obliged.
CL number 9, additional SPP.
My lords, and may it please the court. My lord, criminal reference, in that, my lords, I have filed my appearance, my lords. So insofar as connected appeal is concerned, in that matter, my lords, there are totally 7 accused in this case. There are totally
So file wakalat
eight.
only for 1,
1, 2,
4, 4 to 8.
4 to 8. And also for 1 to
Only 3 you have not filed.
3 is a juvenile, my lords.
He's a junior.
So his case is going on there.
Hmm.
Since there is a conviction under, yes,
Appearing for all the respondents.
all the respondents.
Ah,
So my lords, insofar as
case wakalat not filed.
Wakalat is filed. I have filed my lords.
Wakalat not filed ಅಂತಿದೆ.
Appearance I have filed my lords. Memo of appearance I have filed.
RC.
RC, respondent 1, 2. In RC, my lords, I am respondent 1 and 2. But so in that case, I have filed my memo of appearance. Now, my lords, I have to file an objection to the death penalty. But usually, my lords, the death penalty cases are taken up as an appeal itself. It can be decided only after hearing the matter. Then only this honorable court would be in a position to decide whether it falls under the category of rarest of rare case or whether he is even liable to be convicted under normal circumstances also. So, my lords, that is a peculiar situation before this honorable court. So, we will take this.
This is not something peculiar.
Yes,
Most of these matters, where reference is there, appeal also is filed.
its appeal is also filed.
So therefore, we'll have to consider the appeal.
Appeal also, yes, my lords. So, and appeal, my lords. And since there is a conviction under SC/ST Act also, my lords, the respondent number 1 in connected appeal has to be given notice. That is not directed, my lords. So, a notice will be directed and direction for paper book, we can argue the matter on merits.
Respondent number 1.
Respondent number 1 in connected appeal, my lords. In criminal appeal number 200176.
Respondent number 1, additional SPP.
That is
Respondent
in
number
criminal
2
reference case. There are 2 cases.
No, in your case, in your appeal.
In my appeal, my lords,
In your appeal, additional SPP for respondent number 1
and
or
Saiba
to Sahibanna is served. So notice has been issued. It is served.
served, then served, and I have, that is not reflecting notes.
No,
So
it is there in the
it's-
cause list.
Then the paperwork, my lords, will argue on final hearing.
And as per the direction of the honorable court, my lords, I have served the RC.
So it can be taken up for either final hearing, my lords, or my lords, other issue
But
involved.
you are not pressing on this IA.
I am pressing on the IA. Let them file objection to that IA also.
Ah,
I am pressing on IA also. Because in this case, my lords, the connected appeal, in the connected appeal, responded accused number 4, 5, 6, 7, and 8. My lords, out of this, 4 are women, my lords, and 1 is a male. And in this case, the prosecution itself is that the sister of accused number 1 and 2, who've been given death penalty, she ran away with a boy of Valmiki community, Bedar Samaj. And then it so happened that these people were angry with that relationship. So they bring this girl and they kill her by burning her. And at the relevant time, it is also the case of the prosecution that she was pregnant. That is also not in dispute with regard to pregnancy, my lords. Our defense, the defense which is taken by the trial court, is that it is he who have done it because the girl was very young when she ran away with him. She has filed a POXO case against the accused, against the complainant. POXO case was filed. So he was pestering her to withdraw. She wanted to go back. Once she goes back, the POXO case will continue. To protect himself from the liabilities of POXO Act, he has committed the murder. That is a defense taken up by the trial court. So these two has to be weighed. Now, prosecution in this case has presented, my lords, close to 12 eyewitnesses in this case. But, my lords, but during the course of trial, among the 12 eyewitnesses, only 4 eyewitnesses have supported the case. And those 4 eyewitnesses are mother of the complainant, then sister of the complainant, and husband of PW10, and PW10 is the sister. So she's the sister of the husband of the sister. and cousin. Only 4 close relatives have supported the case. And all other neighbors who were living around, none of them have come before the court and they have supported the case of prosecution. So it becomes now a case where, my lords, people who are interested in the outcome of the case have supported the case, and rest of them have not supported the case of prosecution. And also, my lords, these the appeal, all these people, all accused number 1 to 8, were all on bail. In fact, accused number 1 and 2 were on anticipatory bail in this case. So, my lords, this being the situation, and these women, Ramjan B, the first appellant in the connected appeal, she is 65-year-old, and rest of the people were not even from that village. They were staying somewhere else. So there is a very good chance, and direct allegation, if we have to take the case of prosecution prima facie also, direct allegation of pouring kerosene and lighting her is against accused number 1 and 2. These people, they say that they have assaulted, but since in the view of this, chances of they being part of that incident are very, very slim. And being a woman, my lords, and they also have very small children also. And these children, on that day, when I was informed, the instruction that I have received, on that day, they had gone to the court pronounced the order, and immediately they've taken custody. Children were left in the court itself. From there, some relatives have come, and now the children are staying in different places, in different houses. So there is nobody to actually take care of the children also, or insofar as these small children of these people who are in the prison. So therefore, my lords, this becomes a case where I pray for the sympathy of the court also, because direct allegations also not there. One is a 65-year-old lady. The other prima facie also, my lords, eyewitnesses, the independent eyewitnesses have not supported the case.
I'll file
Only-
objection.
Only,
Till I file one objection.
only.
After that, only it may be heard.
A week's time?
2 weeks time. Because that POXO, what he has submitted, other side, the POXO case was registered and all the documents are to be served.
2 weeks' time is granted at the request of the learned additional SPP to file objections to IA number 1 of 2024 in criminal appeal number 2000176 of 2024.
Yes, my lords, I'm ready. I'm very good.
CL number 10,
But appear for the respondent
Hamza
3, my lord.
Abdul Qadir.
But in this matter, my lord, respond number 1 is, my lord, Govind Reddy, my lord, is the deputy commissioner, my lord. He is not the deputy director, my lord. They made wrongly, my lord, is a deputy director. Deputy director is one, my lord, that is Praveen. Praveen?
Deputy Commissioner of Food and Civil Supplies.
He is the, my lord, not the, he is the deputy commissioner, my lord,
Revenue.
revenue.
Deputy Commissioner Revenue.
Yes, yes, my lord. But he wrongly made the party, my lord. And my lord, who is the competent authority is the, my lord, deputy director, one Praveen Bargal. He has to make the party, my lord.
Answer C is issued by the deputy commissioner, madam.
One in the cost title of the, my lord, before the learned single judge, my lord, page number 18.
The order was passed by the Deputy Director.
But competent authority is, my lord, under section 6E of the Food Civil Supplies my lord, Control Order, my lord. Deputy Commissioner is the authority.
Deputy Commissioner
He is the authority.
Deputy Commissioner Revenue.
Revenue, yes, my lord. Because, my lord, annexure C, my lord, kindly see, he produced, my lord, memo on 20, that is dated 23/1/2024, my lord. He has not furnished the, my lord, correct surety. There is a direction by this court to issue indemnity bond of 500 rupees.
5 lakhs.
5 lakhs rupees, that is given. But insofar as surety is concerned, my lord, is not given clear title of that survey number. Kindly see, my lord, page number 22, my lord. That's why we issued the memo to furnishing correct, my lord. ಆದುದರಿಂದ ಸದರಿ ವಾಹನದ ಮಾಲೀಕರ ಪರವಾಗಿ ನ್ಯಾಯವಾದಿಗಳಾದ ಸೋನ್ಸೋ ಇವರು ನೀಡಿರುವ 5 ಲಕ್ಷ ಇಂಡಿಮ್ನಿಟಿ ಬಾಂಡ್ 100 ರೂಪಾಯಿ ಚಾಪಕದಲ್ಲಿ ನೀಡಿರ್ತೀರಿ. ಆದರೆ this is obtained, my lord, this is 500 rupees, this is given by him, it is complied. ಮತ್ತು kindly sir, ತಾವು ನೀಡಿರುವ ವ್ಯವಸಾಯ ಭೂಮಿಯ ಪಹಣಿ ಪತ್ರಿಕೆಯ ಕಾಲಂ ಸಂಖ್ಯೆ 11ರಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣ ಅಂತಿಮ ಆದೇಶದವರೆಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅನುಮತಿ ಇಲ್ಲದೆ ಮಾರಾಟ ಮಾಡಲು ನಿಷೇಧಿಸಿದೆ ಎಂದು ನಮೂದು ಮಾಡಲು ಶ್ರೀ ವೀರಶೆಟ್ಟಿ ತಂದೆ ಬಾಬುರಾವ್ ಶೆಟ್ಟಿ ಖಡಕ್ ಚಿಂಚೋಳಿ ಇವರ ಸರ್ವೆ ನಂಬರ್ 112 ಸುಲ್ತಾನ್ಪುರ ಗ್ರಾಮದ ತಾಲೂಕಿನ ಹುಮನಾಬಾದ್ ಇವರ ಅನುಮತಿ ಅಫಿಡವಿಟ್ ನೀಡಲು ತಿಳಿಸಿದೆ. There is an encumbrance by the my lord not to alienate this property. So that cannot be accepted as a surety. There is a direction by the Salm Court, my lord. Page number 20, my lord. Para 6. Issue respond number 1 is hereby modified, directing the petitioner to execute indemnity bond of 5 lakhs with one surety for the like sum.
Sir, that mortgage of agricultural land is gone. Please read the order.
Order of the learned single judgment.
Yes. Please read paragraph number 4.
Please. The case of the petitioner is that RC owner.
Paragraph number 4.
4,
Perusal
my
of the
lord,
records.
4, my lord. Perusal of the records course reveals that the aforesaid vehicle was seized under the EC Act. The authority under EC Act has rightly granted permission to release the vehicle, but instead the bank guarantee of 1 lakh along with the mortgage agriculture land, which is horrible and not sustainable in law.
Next Vadi.
This court is various cases directed the trial court and the investigation officer to obtain indemnity bond for the release of the vehicle along with the surety. Such being the case, the order of the authority ordering for the bank guarantee of rupees 1 lakh along with the mortgage of the agriculture land is like liable to be modified. Yes, my lord, that is, we are not, my lord, clear title survey number has to be given to us, my lord.
There is no requirement. Please read, sir.
Because if it
That
is
requirement is taken away.
a,
What is directed is only to give a indemnity bond for 5 lakhs.
that is given, my lord. But like some
Mortgage land, that is
last portion, my lord,
taken away.
para 6, my lord. Para 6 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Understand the order.
That is true, my lord. But here, my lord, that is the, my lord, confusing for us. With like sum ಅಂತ ಹೇಳ್ತಾರೆ. That is with one surety for the like sum ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೇ
Paragraph number 5 makes it very clear.
ಅದು ಕ್ಲಿಯರ್ ಆಗಿದೆ ಇದು.
Such being the case, the order of the authority ordering for bank guarantee of 10 lakhs along with mortgage of agricultural land is liable to be modified.
That is modified, my
So
lord.
ultimately, what is there in the operative portion?
ಅದೇ 5 lakhs ಮತ್ತೆ ಮತ್ತೆ with ಅಂತ ಹೇಳಿದ್ರೆ that is a problem.
That is what? In
Lots of
paragraph number 5, when the learned single judge has said, this is what the authority has said and that cannot be sustained.
That is
And it is modified, directing only the furnishing of indemnity bond for 5 lakhs with one surety. Ashte kelru.
But that is the reason, my lord, we are upright.
Madak barudilla.
Lots of 25th, my lord, you have to make observation, my lord. That is maybe clarified, my lord, then we will release it. Because, my lord, again, my lord, official higher authority will take action against the.
Barkal. Learned government advocate submits that firstly, the competent authority to to pass orders under section 7 of the Essential Commodities Act, 1955 is the Deputy Commissioner, bracketly Revenue. Full stop. Therefore, respond number 1 is required to be amended as Shri Govinda Reddy, IAS, Deputy Commissioner, Bidar District. Huh?
Also. Now he is transferred to Gadag, my lord. He is not there.
Full stop. Further, it is submitted that although the complainant has furnished indemnity bond for rupees 5 lakhs along with one surety for like sum, nevertheless, the complainant has not furnished documents for mortgage of agricultural land full stop. Next para. We have gone through the impugned order. Full stop. In paragraph number 5 of the impugned order, impugned order law, impugned order passed by the learned single judge. Full stop. The learned single judge has clearly held that the order of the authority seeking bank guarantee of 1 lakh along with the mortgage of agricultural land cannot be sustained. Full stop. Consequently, what was directed by the learned single judge is only execution of indemnity bond for 5 lakhs with one surety for like sum. Full stop. Therefore, we find that the authorities cannot insist furnishing of agricultural land for mortgage, since the same has been modified in terms of the directions issued by the learned single judge. Full stop. Next para. If the complainant has furnished the indemnity bond for 5 lakhs along with one surety of like sum, it will be in compliance with the directions issued by the learned single judge. Full stop. If that is so, the respondents are required to immediately comply with the directions issued by the learned single judge. Full stop. Next para. The complainant is also permitted to amend the cause title showing respond number 1 as the Deputy Commissioner, Bidar District. Please do it now. It's next para. Release this matter on 21st of November.
My lord, one submission, my lord. ನಾನು ಹಜ್ಜಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೇನೆ ಸರ್ 6th December ಇಟ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. ಹಜ್ಜಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೇನೆ ಸರ್ 20th.
ಹೋಗಿ.
Okay, sir.
6th December ಬೇಕಾ?
Yes, sir.
ಹಿಂಗೇನ್ರಿ ಇಂಟ್ರೆಸ್ಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡೋದು ನಿಮ್ ಕ್ಲೈಂಟ್?
ಇಲ್ಲ ಸರ್. ಇಲ್ಲ ಸರ್, ಹಜ್ಜಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೇನೆ ಸರ್.
ಮುಂಚೆನೆ ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ ಅಂತ ಕೇಳ್ಬೇಕು.
ಮುಂಚೆ ಕೊಡಿ ಸರ್, ಮುಂಚೆ ಮಾಡ್ತೀನಿ ಸರ್.
ನಾನು ಹಜ್ಜಿಗೆ ಹೋಗ್ತಾ ಇದೀನಿ, ಮೂರು ವಾರ ಮುಂದಕ್ಕೆ ಹಾಕ್ರಿ ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ರಿ?
14-15 ಕೊಡಿ ಸರ್. 14-15 ಕೊಡಿ ಸರ್.
ಯಾವ 14-15?
ಇದೆ ನವೆಂಬರ್
ಮಾಡಿದ್ದು. ಆಗಲ್ಲ, ಆಗೋದಿಲ್ಲ. 6th December. Yes.
Serial number 11, Ravi B. Patil.
These matters, my lord, you was heard, my lord, last occasion, my lord, regarding this is not Waqt property. But Waqt is not challenged the, my lord, order of the learned single judge. That is not, we are no more to add, my lord, lots, I'm giving to lords, my lord, to pass order on this, my lord. Our submission, yes, my lord, that is.
Writ appeal.
Yes, my lord. This batch of writ petition, my lord, there is totally 5 writ appeals, my lord, filed by the state, not by the Waqt board.
Which is that earlier order where
At
the
first.
division benches passed the order?
I had passed.
Put it.
Nurja.
It appeals to 007 of the copies served.
Note release the note.
Supreme Court. confirm.
ಕಡಿಮೆ ಮಾಡಿದ. Respond number 5 has to work out its remedy now. Respond number 5 are really. Respond number 2 ಇರಬೇಕಾಗಿತ್ತು. Paragraph number 11 ಅಲ್ಲಿ respond number 5 ಅಂತ ಹೇಳ್ತಾರೆ. There is no respond number 5, only respond number 2.
Writ petition. The only difference in this case and present case, is, then it was 95/5. Now, due to amendment, it is 7 days. Earlier, it was 4 months.
ಅದೇ ಅದೇ.
Adu ಒಂದು change. Due to 22 amendment.
Respond number 5 is the writ petition.
Only 7 days.
ಹೌದು.
7 days.
ಹೌದು sir. If it is within CDP limit, 7 days. If it is outside CDP limit, it is 1 month.
30 days ಇತ್ತಲ್ಲ.
If it is within CDP limits, it is 7 days. Clause 2 amendment. If any occupant, your lordship, if any occupant of a land assessed or held for the purpose of agriculture wishes to divert such land or any part thereof to any other purpose, he shall submit an affidavit along with an application to the deputy commissioner in the manner as prescribed. And if a diversion is sought in accordance with the use specified in master plan, duly published for the concerned land under the provisions of the Karnataka Town and Country Planning Act 1961, then the same shall be deemed to have been diverted subject to payment of a prescribed fee under subsection 7 of, and the deputy commissioner shall issue the order of approval accordingly within 7 days from the date of receipt of the application. Provided that in case of a deputy commissioner fails to give his decision and issue the order under this subsection within 15 days from the date of receipt of the application, the approval for diversion for use shall be deemed to have been granted by the deputy commissioner, and the same shall be certified and issued after payment of a fee prescribed under subsection 7 in manner as may be prescribed. Then if it is outside, in the case.
And where do you find that it falls within the CDP?
I have produced the master plan along with my writ petition in the before the learned single judge, which is a part of my writ appeal now.
It should have been a ground in your writ petition, sir.
It is.
Point out from that one.
Please.
ಅವರ writ appeal papers ಕೂಡ ಅದರಲ್ಲಿ ಇದೆಯಾ ನೋಡ್ರಿ. writ petition
193.
memorandum of writ petition ಇದೆಯಾ ನೋಡಿ.
2,193 of 2024.
ಅದಲ್ಲ memorandum of writ petition ತೆಗೀರಿ. ಕೊಡಿ. Where have you stated? Paragraph number 10.
Yes. Yeah, early earmark for residential purpose is 7 days from the date of application. The endorsement issued after the prescribed period by the office second respondent is one without jurisdiction. As in of operation of law, the land is deemed to have been converted and only order could be passed by the deputy commissioner is assessment of requisite conversion fee as deputy commissioner become functions officio.
So when was the endorsement given?
Lord, this is after, Lord, the endorsement is at page number.
When did you file the application?
Application, Lord, annexure G, my lord.
ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ರಿ ಎಲ್ಲದಕ್ಕೂ ತೆಗೆದು ನೋಡಕ್ಕಾಗಲ್ಲ ನಮ್ಗೆ.
ಹೌದು.
Please a copy of the application dated 23/3/2023.
Yes.
Deputy Commissioner order
25/1/2020. 24. 25/1/2024.
Twenty-five one
2024.
So after 40 days.
ಹೌದು. Yes.
ಬರ್ಕೊಳ್ಳಿ. ಇದು ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ. This writ appeal, intra-court writ appeal has been filed by the state of Karnataka, the deputy commissioner, Bidar district, the assistant commissioner, Bidar subdivision, and the Tahsildar, Bidar Taluk, following in question, order dated 14th of February 2024, passed by the learned single judge in WP number 200466 of 2024. Full stop. Next paragraph. The respondent number 1 had filed the writ petition. Calling in question, endorsement dated 25/1/2024 issued by the deputy commissioner, Bidar district, rejecting the application filed by respondent number 1 for conversion of property bearing survey number 61 **10 bracket 61 *AA close bracket, measuring 2 acres 10 guntas, situated at Haladkeri bracket K close village, Bidar Taluk and district. Stop. The rejection of the application was on the ground that the property is gazetted and notified as work property. Full stop. The learned single judge, having considered the contention of the writ petitioner and the appellant herein, held that the deputy commissioner has rejected the application after the lapse of the statutory period in terms of the relevant provisions of the Karnataka Land Revenue bracket ಅಲ್ಲಿ second amendment close act 2022. Full stop. It was observed that the application was filed on 23/3/2023 and the deputy commissioner passed the order on 25/1/2024 beyond the permissible limit, permissible time. Full stop. Consequently, the writ petition was allowed while quashing the endorsement issued by the deputy commissioner. Full stop. Positive directions were issued to the deputy commissioner to effect conversion and issue conversion certificate in favor of the petitioner, writ petitioner, after collecting necessary charges for conversion, in accordance with law, within a period of 3 months from the date of receipt of a certified copy of the order. Stop. Next para. Learned counsel for the first respondent brings to the notice of this court orders passed by a coordinate bench of this court in writ appeal number 20007 of 2022, which was filed by the very same appellants herein in respect of similar orders passed in writ petition number 201968 of 2017, dated 5/3/2021. Full stop. It is pointed out that the division bench took note of the submissions made on behalf of the second respondent herein, namely the district work officer, district work advisory committee, Bidar, who contended that the land in question is said to be Ashur Khana Inam land. Stop. The coordinate bench took note of similar endorsement issued by the deputy commissioner, who had rejected the application after nearly 2 years, while stating that the property was a notified Waqf property. Full stop. The coordinate bench also considered the judgment cited on behalf of the state and the deputy commissioner that the Honorable Apex Court in the case of Syed Ali and others versus Andhra Pradesh Waqf Board, Hyderabad and others citation really.
Reported in 1998 one SCR.
Huh?
But that is para 8 of my ground appeal, my lord.
ಇದೆಯಾ?
Aide.
ಹೇಳಿ.
1998 one SCR.
(1998)
SCR.
bracket 1 SCR Supreme Court reporter. Page number
Stay this.
ಅದನ್ನ ನೋಡ್ಕೊಡ್ರಿ. Wherein it was held that once the property is notified as work property, it would be a permanent dedication. Full stop. On the contrary, the coordinate bench upheld the contentions of the original writ petitioner that this court, in the case of Karnataka State Board of Waqfs and another versus State of Karnataka and others and connected matters in writ appeal number 5591 of 2011, bracket really GM dash Waqf, close bracket, connected with appeal number 379 of 2012. Wherein it was held that grant orders were passed in favor of the original owner in the year 1987, and the said order remained unchallenged, and therefore the claim that the property is work property is unsustainable. Full stop. Consequently, having noticed the provisions contained in section 95 bracket 5 of the KLR Act, which provides for a deeming provision, and the fact that the endorsement was issued by the deputy commissioner after the lapse of the mandatory period prescribed therein, the coordinate bench proceeded to dismiss the appeal filed by the state and the deputy commissioner. Stop. It is also pointed out that the state and the deputy commissioner had further taken up the matter before the Honorable Apex Court in SLP bracket civil close number 53315 of 2023, and the said SLP was dismissed on 14/5/2024. Full stop. That view of the matter, learned counsel for the first respondent would submit that since similar appeals filed by the appellants herein have been dismissed earlier and the same has been confirmed at the hands of the Honorable Apex Court, this writ appeal also should be dismissed. Next para. ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಳ್ಳಿ submission on behalf of respondent number 1. Next para on ಮಾಡ್ಕೊಂಡು the learned counsel for respondent number 1 would further submit that Section 95 of the KLR Act has further undergone amendment in terms of the Karnataka Land Revenue bracket Second Amendment Closed Act 2022, whereby Clause 1 of subsection 2 of Section 95 mandates that if the diversion is sought in accordance with the use specified in the master plan duly published for the concerned land under the provisions of the Karnataka Town and Country Planning Act, 1961, then the same shall be deemed to have been diverted, subject to payment of prescribed fee under subsection 7, and the Deputy Commissioner shall issue the order of approval accordingly within 7 days from the date of receipt of the application. Stop. The proviso further mandates that if the Deputy Commissioner fails to give his decision and issue the order under the said subsection, within 15 days from the date of receipt of the application, the approval for diversion for use shall be deemed to have been granted by the Deputy Commissioner, and the same shall be certified and issued, after payment of fee prescribed under subsection 7 in the manner as may be prescribed. Full stop. The learned counsel would point out from the memorandum of writ petition that the petitioner has clearly stated that the land in question forms part of the master plan of Bidar city. Bidar city. And the same is earmarked for residential purpose. Full stop. It was therefore contended in the writ petition itself that the approval should have been granted by the deputy commissioner within 7 days from the date of receipt of the application. Full stop. Next paragraph. For contra, learned government advocate seeks to support the endorsement issued by the deputy commissioner. Full stop. Learned counsel Shri Liaquat Ali, Liaquat Farid Ustad, appearing for respondent number 2, the Chief Administrative Officer of the Karnataka State Board of Awqaf, would contend that opportunity of hearing should be given to the second respondent to contest the application filed by the first respondent. Full stop. If opportunity is not given, then the second respondent and the work board will be losing precious immovable property which have been notified as work property. Full stop. Next paragraph. Having heard the learned counsels, learned government advocate, learned counsel for respondent number 1, learned counsel for respondent number 2, and on perusing the appeal memo, appeal papers, this court of the considered opinion that whatever had to be done by the deputy commissioner was required to be done within the stipulated period of 7 days. Full stop. However, insofar as the claim of the second respondent herein is concerned, it will be open for the second respondent to redress its grievance in accordance with law. Full stop. the Deputy Commissioner. In terms of subsection 2 of section 95. Is permitted to verify from the documents submitted along with the application as to whether the occupant of the land assessed or held for the purpose of agriculture is the registered khatedar. Full stop. Having regard to the fact that the original writ petitioner submitted the record of rights which shows that in terms of mutation order number 26/2003-2004 dated 29/5/2004, the name of the original writ petitioner is entered in the record of rights as the owner of the property, owner and occupant of the property in question, then it would not be open for the Deputy Commissioner to contend that the land in question is a work property. Full stop.
One more hissa is already converted.
Huh?
One more hissa number, my lord, 6 is already been converted. Page number 47. Annexure. Same survey number.
See, why we are passing this elaborate order is that at least it will be clear as to how this court has considered all this, and it will be a guideline for the Deputy Commissioner.
Yes.
Otherwise, simply they go on doing the same thing. The only manner that would be open for the work board is to have its name registered in the record of rights. Without that, it cannot raise any objection.
Yes.
So therefore, we are giving all these reasons,
Yes.
and we are also permitting the work board to get its grievances redressed only in accordance with law.
Yes.
Unless and until his name is entered in the record of rights, the Deputy Commissioner could not have given this endorsement.
Yes.
The work property. Similarly, it will not be open for the second respondent herein to contend that the property in question is a work property comma, unless the same is accepted and such name is the such name of the Waqf board or any other institution is reflected in the record of rights. Full stop. Next para. Consequently, we proceed to dismiss the writ appeal. Accordance with law ಅಂತ ಬಂದಿದೆ. We will ಇವಾಗ ಇದರಲ್ಲಿ ಕಂಟೆಂಟ್ ಪೆಟಿಷನ್
May I request one? Should, since one more 16 matter, my lord, where it is beyond CDP limits. There are two, my lord, diversion. One is
Oh.
if that is extracted in entirety
this case would apply
to CDP.
serial number
Similar ಹೇಳಿ ಯಾವ್ದು correct.
12, 13, 14.
11 and
11.
and 12. ನಿಮ್ದು
ನೀವು ಒಂದು ಪೇಪರ್ ಅಲ್ಲಿ any changes
Yes.
in the facts, even in respect of 12 and other matters which fall within the master plan.
Yes.
ಅದನ್ನ ಒಂದು ಪೇಪರ್ ಅಲ್ಲಿ you just say what are the changes that are to be done.
Yes.
ಸರ್ವೆ ನಂಬರ್, ಎಕ್ಸ್ಟೆಂಟ್,
Yes.
ಅಪ್ಲಿಕೇಶನ್ ಡೇಟ್ ಏನಾದ್ರು ಚೇಂಜ್ ಇದ್ರೆ ಅದು,
Yes.
ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಡೇಟ್ ಚೇಂಜ್ ಇದ್ರೆ ಅದು, ಅಷ್ಟನ್ನ ಮಾತ್ರ ಒಂದು ಪೇಪರ್ ಅಲ್ಲಿ ಪ್ರತಿ ಒಂದು ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟು ಅದನ್ನ ಬರ್ಕೊಟ್ಬಿಡಿ.
Please.
So we are passing individual separate orders. ಅದಕ್ಕೆ we are passing separate orders so that everything will be clear.
Yes.
ಯಾವುದು which is the one that is not within the master plan?
16, my lord.
16.
Where it comes 30 days.
16 ಅಲ್ಲಿ ಆ ರೆಲೆವೆಂಟ್ ಚೇಂಜಸ್ ಮಾತ್ರ ನಾನು ಹೇಳ್ತೀನಿ, ಅದನ್ನ ಆಮೇಲೆ ನೀವು ಅದನ್ನ ಡ್ರಾಪ್ ಮಾಡ್ಕೊಡಿ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಆ ಸಬ್ಮಿಷನ್ ಆಫ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಆ ಸಬ್ಮಿಷನ್ಸ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳಿದ್ವಲ್ಲ, ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಸೆಕೆಂಡ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್ 2022 ಅಂತ, ಅದರಲ್ಲಿ ಕ್ಲಾಸ್ 2 of subsection 2 of section 95 mandates that if the land does not fall within the local planning area, then concerned authorities shall furnish their opinion within 15 days from the date of receipt of the application. Full stop. The deputy commissioner is bound to issue the approval for diversion for use as per the application, subject to the opinion furnished by the concerned authorities and subject to payment of fee prescribed under subsection 7, within 15 days full stop. If the deputy commissioner fails to furnish the opinion within 15 days. Comma, it shall be deemed that the concerned authorities have no objection to the said diversion of land so further, if the deputy commissioner fails to give his decision and issue the order within 30 days from the date of receipt of the application, comma, the approval for diversion for use shall be deemed to have been granted by the deputy commissioner. And the same shall be certified and issued in the manner as may be prescribed, subject to payment of the fee prescribed under subsection 7. Stop. Learned counsel submits that ಅದರಲ್ಲಿ ಅದು ಕೊಟ್ರಿ that the application was given by the petitioner, the writ petitioner,
Nineteen-one twenty-three, my lord.
19/1/2023. Endorsement was given by the deputy commissioner on 23/5/2023. Comma, that is beyond the period of 30 days as prescribed in the province. Yes.
13, 14, little different facts, my lord.
13
and 14.
Number 12, LB party.
Appear. Same.
ಅದೇ ನೀವು ಅದು ಎಲ್ಲಾದ್ರೂ ನೀವು ಪ್ಲೀಸ್ ರೈಟ್ ಇಟ್ ಇನ್ ಪೇಪರ್ ಅಂಡ್ ಗಿವ್ ವಾಟ್ ಆರ್ ದಿ ಚೇಂಜಸ್
Please.
In 13 and 14, there is no endorsement at all.
ನೋ ಎಂಡೋರ್ಸ್ಮೆಂಟ್.
Therefore, this fact should not come, my lord, the order. The trust should be the same, but there is no endorsement issued at all, even till today. Therefore, my lord, only deputy commissioner is made party there. And the lapse of 4 months has filed a petition.
ಯಾಕ್ರಿ ಅದ್ರಲ್ಲೂ ಯಾಕ್ರಿ ಮಾಡ್ತಾ ಇಲ್ಲ? ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ವಂತೆ.
Deemed already in accordance with law, it becomes a deemed conversion.
No, there is an order passed by the learned single judge, isn't it?
Yes. Yes.
ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. Then why are they keeping quiet then?
Contempt ಹಾಕಿದಿದೆ. After filing contempt only, they have filed writ appeal in this.
ಇದರಲ್ಲಿ ಏನು contention? If you have not issued any endorsement, what is your contention?
Appeal ಏನಿಲ್ಲ, ಇದು opportunity ಕೊಟ್ಟಿಲ್ಲ, work ಅಂತ ಹೇಳಿ. They say again the work, it's a work, there is a para 7 of the writ appeal.
How can you contend like that without issuing endorsement? ಮಕ್ಕಿ ಕಾ ಮಕ್ಕಿ ಅದ್ರಲ್ಲಿ ಏನೋ ಮಾಡಿದ್ವಲ್ಲ ಅದೇ ಗ್ರೌಂಡ್ಸ್.
ಅದೇ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಬಂದಿದ್ದು ಅದೇ ಪರ ಮಾಡಿದ್ವಿ. Within 2 days, my lord. 12th filed, 14th disposed of.
ಇಲ್ಲ. On 31st.
ಕೇಸಲ್ಲಿ previous cases, my lord, 12th filed. 14th ಅಲ್ಲಿ ಕೇಸ್ ಬಂದಿದ್ದು same day it was disposed of.
ಇಲ್ಲ.
ಕೇಸ್
ಹೌದು.
ರಿಪಿಟಿಷನ್.
Petition.
ಇಲ್ಲ.
ಹೌದು.
13 ಮತ್ತೆ 14
13 and 14
ಎರಡರಲ್ಲೂ
ಇಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಅವ್ರ ವರ್ಕ್ ಎರಡರಲ್ಲೂ ಸೇಮ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ.
13 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ.
This is within 7 days ought to have been passed an order CDP master plan ಬರುತ್ತೆ.
So it falls within the master plan.
This 13,
13
14 would not fall.
13 ಅಲ್ಲಿ ಹಂಗೆ ಬರ್ಕೊಳ್ಳಿ. Falls within the master plan area. ಆಯ್ತಾ? ಆಮೇಲೆ
No.
no endorsement is issued
No
by the deputy commissioner. So ಅದಕ್ಕೆ ನಾವು ಇದ್ರ ಬಗ್ಗೆ ಏನೇನು ಹೇಳಿದೀವಿ, ಆಫ್ಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಓನ್ಲಿ 7 days ಬಿಕಾಸ್ ಇಟ್ ಫಾಲ್ಸ್ ವಿತ್ ಇನ್ ದಿ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್, ಅದೆಲ್ಲ ಬರಲಿ. ಅದಾದ್ಮೇಲೆ ಫರ್ದರ್ ಸಿನ್ಸ್ correct, since the deputy commissioner has failed to consider the application or issue any endorsement, it is a clear case of deemed conversion. Stop. We therefore proceed to uphold the orders passed by the learned single judge.
City limit
ಅಷ್ಟೇ ತಾನೆ?
Yes.
13 ಮತ್ತೆ 14.
14 with the outside the
Outside the
1 month time
outside the planning area,
planning.
not within the planning area. So 30 days.
Yes,
Within
30
30 days.
30 days.
They are required.
Contempt
They
are
are required to comply.
contempt are
Of the dismissal.
Tempted to de-linked, my lord, then you also have it after 2 weeks, my lord.
Dealing ತಲ್ಲ ಇದು dispose
Yes,
ಆಯ್ತಲ್ಲ.
my- After 2 weeks, my lord, any date may be fixed, my lord.
ಎಲ್ಲಾದು ಕಂಟೆಂಪ್ಟ್ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ since we have
my lord already
dismissed the appeals preferred by the state and the deputy commissioner, by order of event date, we hereby direct the deputy commissioner, respondent deputy commissioner to collect the necessary fee
already paid.
paid.
ನಮ್ದ್ರಲ್ಲಿ paid ಮಾಡಿ.
ಇಲ್ಲ ಕೆಲವುದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ನಮ್ಮ assessment deed
ಇಲ್ಲ ಮಾಡಿ ನಾವು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ಲ
If
notice.
not already paid,
ಒಂದು deal conversion ಅಂತ ಬಂದವಲ್ಲ. Assess ಮಾಡಿದ್ದು.
and proceed to pass necessary orders while issuing certificate of conversion in terms of the deeming provision contained in section 95 of the KLR Act within a period of 2 weeks from today. Full stop. ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ
ನಮ್ದಕ್ಕೆ assess
ಇಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ನಿಮ್ದ್ರಲ್ಲಿ ಪೇಮೆಂಟ್
ನಮ್ದು ಒಂದ್ರಲ್ಲಿ ಪೇಮೆಂಟ್ ಆಗಿದೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅಸೆಸ್ ಮಾಡಿ.
ಕಾಮನ್ ಆರ್ಡರ್ ಇರ್ಲಿ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೇ ತರ ಬರೀರಿ. ಇನ್ ಕೇಸ್ ವೇರ್ ದಿ ಒರಿಜಿನಲ್ ರಿಟ್ petitioner has not paid the requisite fee, we hereby direct the deputy commissioner to inform the writ petitioner within a period of 1 week from the date of receipt of a copy of this order regarding the fee payable. Full stop. On receipt of such information, the original writ petitioner shall make the payment accordingly within a period of 1 week from the date when the information is received from the deputy commissioner. Full stop. Relist these matters on 27th of November.
Please.
Right.
Serial number 15, Siddharudha B. Pujari.
For complainants. In this matter, my lord, 1 more week, my lord, require, my lord. For issue of form number 10, my lord,
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಇದ್ರದನ್ನ
same, same.
ಬಿಯಾಂಡ್ ಸಿಡಿಪಿ 16 ಆಗಿದೆ. ಸೊ 15 ಮಧ್ಯದಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಬೇರೆ.
ಬೇರೆ contempt. Otherwise, 1 week time may be granted, my lord, in this matter. Is serial number 15, my lord. Place a week's time, my lord, for body and issue of the form number 10. The manual ಮಾಡಬೇಕಾಗಿದೆ, online ಇದ್ದಿದ್ರಿಂದ manual ಮಾಡಬೇಕಾಗಿದೆ. That is the problem, my lord, we are facing. That's why I'll also private on 19th or 20, my lord, by that time we will do.
At the request of the learned government advocate, release this matter on 20th of November.
Please.
Serial number 17, DG Chakshetty.
I am appearing for the particular complaint.
In 18, my
The
lord,
learned single
CMC
judge granted an interim order directing the respondent not to demolish the standing structure mats. In spite of it, they have demolished.
Interim order,
The interim order mats.
interim order.
Yes, mats. Interim order to the effect that not to demolish the standing structure, which was brought to the notice of the response
Notice ಏನಾಗಿದೆ?
while representation.
Notice ಏನಾಗಿದೆ?
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಬಂದಿದೆ ಅಲ್ಲಿ, acknowledgement not received ಅಂತ. TMC, my lord, it is.
CMC.
TMC.
Chief Officer TMC, Muddebihal. Await police report. ಇನ್ನು ಬಂದಿಲ್ಲ.
But I'm told, my lord, yesterday it is served to, my lord, the chief officer. I'll undertake.
Learned Counsel Shri Harshavardhan B. Malipatil,
R. Malipat.
R. Malipat undertakes to appear for response number 1 and 2.
No, my lord, for only one.
Response number 1,
Chief officer.
the chief officer TMC, Muddebihal.
I'll
Stop. A week's time is granted.
but I request for 2 or 3 weeks. There is some, my lord, issue regarding that demolition, my lord. I'll file, my lord, all.
ಅಲ್ಲ, ವಕಾಲತ್ ಹಾಕಕ್ಕೆ.
ವಕಾಲತ್ ಹಾಕಕ್ಕೆ ಒಂದು ವಾರ. I'll be doing that, my
A
lord.
week's time is granted to learned counsel to file wakalat.
Great.
Next para. At the request of learned counsel, Shri Harshavardhan Malipatil released this matter on 25th of November.
Pleasure.
Yes.
Meanwhile, my lord, the
ಅಲ್ಲ,
service.
demolish ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? What
Service
will you
to-
do now?
No. The issue is, my lord, we have, my lord, taken demolition, my lord, action in a different portion, not their portion.
No.
There is no, my lord.
ಅವ್ರ ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಾಕಿದ್ದಾರೆ.
And building was not out of.
I will demonstrate that road, what buildings are there and what, Lord, I will have to, Lord, get instructions, Lord. After that, I will make myself.
Yes.
The other party also, Lord, notice may have to.
ಅವರು ಪ್ರೆಸಿಡೆಂಟ್ TMC.
Yes, the liability is. President TMC, Lord. I'll instruct him, Lord, because I don't have instructions to appear, Lord, if he gives.
Yes.
Serial number 18. Serial number 18.
Identical.
Same,
matter.
same.
Serial number 19, Sagar Ramachandar.
Yes.
Due to oversight, filed in MFA,
Conversion of MFA into
RPFC.
RPFC. Revision petition. ಇದು ಸಿಂಗಲ್ ಬೆಂಚ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದು
Sir, division,
ಹಾ
division.
ಹಾ ಸಿಂಗಲ್ Senate counsel for the appellant has filed a memo seeking conversion of this miscellaneous first appeal into RPFC. Full stop. It is doubtful as to whether the RPFC would be listed before division bench. Full stop. Therefore, we proceed to dismiss the appeal while reserving liberty to the appellant file RPFC on the same cause of action. Yes.
File number 20, hearing Harshvardhan R. Mali Patil.
My lord, I have submitted, my lord, the appeal memo ಕೊಡ್ತೀನಿ ಅಂತ connected ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು. Madam Shivogi madam is appearing in the writ appeals in Bangalore pertaining to Vijayapura. ಇದರಲ್ಲಿ last date ಬಂದು ಸ್ವಾಮಿ connected matters are the writ appeals 437 to 445. ಅವು ಒಂದು
ಇದ್ರದ್ದು ಹೇಳ್ತಾರೆ
lake rejuvenation.
rejuvenation.
One week, 2 weeks, I will get all the details. ಯಾವ್ದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತ ತಾವ್ ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ, ಅದನ್ನು ಒಂದು ವೆರಿಫೈ ಮಾಡ್ತೀನಿ. ಬಂದಿಲ್ಲ ಅಲ್ಲಿ 5/4/23 ಬಂದು ಹೋಗಿದೆ ಡೇಟು, ಆಮೇಲೆ ಬಂದಿಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ. ಕನೆಕ್ಟೆಡ್ ಒಂದು 6 ಅಪೀಲ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ.
ಯಾವ ಪ್ರಾವಿಷನ್ ಇದು? ಯಾವ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಒಳಗಡೆ?
ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಆಕ್ಟ್, ಟೌನ್ ಅಂಡ್ ಕಂಟ್ರಿ ಪ್ಲಾನಿಂಗ್ ಆಕ್ಟ್ ಕೆಳಗೆ.
Now only remedy what we are seeking.
It is regarding leaving the
Cess.
cess on the water body.
Which is that provision?
18(1)(a). Amendment Act, my lord, 2015. Now it is again, my lord, amended. Okay. Other amendment.
They are seeking refund on the
What happened,
basis of subsequent notification.
2015, my lord, they made a regulation, not inserted 1A, wherein 1 lakh rupees towards lake rejuvenation, my lord, was imposed whenever, my lord, conversion is sought for per acre.
ಯಾವ ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ ಮಾಡಿದ್ದು?
2015, my lord, 10/9/2015.
Which is that clause?
Section 18(1)(a). ಕೆಳಗಡೆ subsection old act ಅನ್ನಲ್ಲಿ ಇರ್ಬೋದು. It's also enclosed in the petition. 1A.
18A.
ಹೌದು.
1.
ಇಲ್ಲ 18(1)(a). Section 18A definite. Section 18 ನಲ್ಲಿ.
In inserting clause 5, Roman 5 in section 18A.
18(1) may I request, my lord?
2015.
2015 amendment ನಲ್ಲಿ where an application for sanction of subdivision of is a plot or make layout.
Where an application for
subdivision of a plot or make or layout.
1A ಓದ್ತಾ ಇದ್ರ ನೀವು?
ಹೌದು.
1A.
ಹೌದು. 2015.
Where an application for permission for development of building or
ಇದು
land.
ಈಗಿನ amendments. This is my lord, which is substituted now.
earlier old,
Prescribed fee for rejuvenation of lakes or tanks, if any, in that local planning area.
yes,
That was the first,
yes, my lord, 1 lakh rupees.
provision.
1 lakh rupees, my lord,
Per acre.
per acre.
Ah,
Throughout the state, my lord, it was a unilateral imposition of, my lord, the assess towards lake rejuvenation.
ಇಲ್ಲ ಪ್ರಾವಿಷನಲ್ ಇಲ್ಲ ಆ ತರ. An additional prescribed fee ಅಂತಿದೆ ಅಷ್ಟೇ ಇಲ್ಲಿ.
ಹೌದು.
ಹಾ.
ಈಗ ಆಗಿರೋದು sir. Your lordship could see, my lord, old reference, my lord, at the bottom. Old reference.
ಇದು ನಮ್ದು 2021 ಇದು.
ಹೌದು.
ಇಲ್ರಿ ಹೊಸದಿಲ್ರಿ. ತರ್ಸ್ಕೊಳ್ರಿ. ಓದಿ.
Old reference was, my lord, 1A, where.
Old ನಮ್ಮ ಹತ್ರ ಇದೆ ಇಲ್ಲಿ.
ಅದೇ.
You read the new one.
New is where an application for permission for development of building or land or sanction of a subdivision of a plot or layout of a private street is submitted under section 15 or 17 to any planning authority. Such planning authority shall levy and collect an additional prescribed fee for rejuvenation of lakes or tanks.
This is what was done in 2015.
Yes, my lord.
Which is the new one, new amendment ಯಾವಾಗ ಬಂದಿದೆ?
ಇಲ್ಲ, this has been substituted in 2015. Earlier old reference may request. Old reference may request.
Old reference.
Old reference ಕೆಳಗಡೆ bottom ನಲ್ಲಿ.
3/1/2012.
3/1. ಹೌದು.
ಓದಿ.
Amendment.
Where an application for sanction of subdivision of his plot or make or layout a private street is submitted under section 17 to any planning authority. Such planning authority may levy and collect an additional fee at the rate of rupees 1 lakh per acre of land for the purpose of rejuvenation of lakes or water bodies within the planning area. Unilaterally throughout the state, 1 lakh.
They had fixed 1 lakh.
Yes.
Now that in 2015 they removed it and said prescribed fee.
Now prescribed, my lord, now they have made it based on the population, which could be found, my lord, at Rule 37A, Table 3. Earlier it was not framed. No rules were also framed, my lord, when the earlier Rule 37A, my lord. Table 3. Just above that, my lord, 1A, my lord, if your lordship could see, my lord, about 3. 1A, additional fee to be levied under section 18(1)A for rejuvenation of lakes or tanks. Under section 18(1)A, if the act had additional fee to be levied by the planning authority or local authority, as the case may be, for granting permission for a development of a building or land under section 15 or 17, shall be at the rate specified in the table below, namely. Now, local planning area within Bangalore metropolitan region, irrespective of population, rupees 25 per square meter. Per square meter. My lord, we come under, my lord, 3. Gulbarga comes under 3. Local planning area with a population of 1 lakh and above, but less than 10 lakh, 15 rupees. Earlier it was 1 lakh throughout the state. What we challenge, my lord, the market value of the land itself here in either, my lord, as per the government guidelines, was 3 lakh rupees per acre. However, my lord, this imposition of 1 lakh rupees throughout the state was, which was crossing more than 30% of the cost of the land. And there was no.
What is the consequence of this amendment?
Now, consequence of this amendment, we were permitted to deposit money, my lord, pursuant to, my lord, the interim order granted by learned single judge, subject to result of the writ petition. Now, my lord, pursuant to the interim order, we deposited, my lord, the amount. My lord, in first matter, my lord, it is 40 lakhs. Second matter, it is, my lord, the 60 lakhs. Now, if this table is incorporated per acre, my lord, now it is, my lord, 60,000 instead of 1 lakh. We will be entitled for the benefit of 40,000. Therefore, my lord, I have filed an application seeking amendment, seeking, my lord, to retain, my lord, the 60,000, whatever is applicable as per the now, my lord, the criteria which has been fixed by the state. Remaining amount, my lord, which is in excess. My ground of challenge was same, my lord. Unilateral imposition is illegal, and, my lord, there is no corresponding rules framed therein.
This is writ appeal.
How?
What happened to the writ petition?
My lord, adopting the decision, my lord, taken in the principal bench, where, my lord, constitutional validity only was challenged.
On the basis of this judgment, my lord, the writ petition was dismissed. WP number 37442-37443 of 2012. On the basis of the covered by judgment, my lord,
You know?
the writ petition dispose the judgment ಆಧಾರದ ಮೇಲೆ. Against that, this appeal is filed by the layout owner. The constitutional validity was upheld.
Hmm.
The state has got power to amend the act provisions, my lord. And thereafter, subsequent amendment has came into force. In the subsequent amendment, the amount is reduced. Now, on the basis of that, my lord, they are claiming a refund of the amount. At the time of the layout approval, that was the law which was prevailing. Accordingly, they have paid the money, my lord, and in the form of bank guarantee. And immediately after the disposal of the writ petition, that bank guarantees were invoked and they were encashed. Now, my lord, without there being any prayer, now, my lord, on the basis of, my lord, earlier writ petition order only, they are filed the writ appeal and they are claiming now with an amendment for refund of the money. My lord, let them file. My request is that, my lord, let them amending this petition, let them file the application for refund on the basis of the provisions. What the authorities will answer, my lord, then they have to approach this honorable court. This is my submission. Therefore, my lord, all the writ petitions are pending. In this principal bench also, my lord, the hundreds of petitions are pending, writ appeals are pending.
ಇಲ್ಲ ಅಲ್ಲಿ ಈ ಪಾಯಿಂಟ್ ಯಾರು ಕ್ಲೇಮ್ ಮಾಡಿಲ್ಲ ಸರ್. I have strictly
ಇಲ್ಲ.
filed an application
Appeal
seeking
ಹಾಕಿದ್ರೆ madam
only to rely upon the further amendment now.
ಅವರು ಹಾಕಿದ್ದಾರೆ, ಹಾಲಹಳ್ಳಿ ಅವರು ಹಾಜರ, ಅವರು ಇದ್ದಾರೆ, they are also pending and
Other
challenged.
grounds are not been considered while considering, my lord, the validity, my lord, of the enactment. Now, my lord, since amendment is by way of substitution, it's not by way of insertion. Therefore, that benefit will, my lord, accrue to the.
It is subsequent to the payment, my lord. Already it was approved, 40 acres and 60 acres. Nearly saying, my lord, 60 lakhs ಕೊಟ್ಟಿದ್ವಿ. Per acre 1 ಲಕ್ಷ ಅವಾಗಿನ ಕಾನೂನು ಅವಾಗಿತ್ತು, ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. Subsequently change ಆಗಿದೆ. Subsequent change ಆಗಿರೋದು ಆಧಾರ ಮೇಲೆ ವಾಪಸ್ ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ. That can't.
Substitute ಆಗಿದೆ. Provision substitute ಆಗಿದೆ.
Of January 2015, this order was passed.
Yes.
This is coming into effect from 10/9/2015. This provision.
Yes, ma'am.
It is substituted. Earlier provision is been substituted. Because there was no calculation, unilaterally it was, my lord, incorporated 1 lakh rupees per acre, irrespective of, my lord, the population, irrespective of the place, irrespective of the market value of the property. And, my lord, even subclause 5 to section 18A, where, my lord, it was a cess. The cess, my lord, cannot exceed more than, my lord, prescribed valuation. That was also substituted now. Adanu delete madbitu. Now the government has considered that there was some defect and therefore they have formulated the rules and, my lord, they have substituted the earlier rule.
So after filing this writ appeal,
Yes,
the provision was amended.
How?
yes, ma'am.
How?
Therefore, a fresh cause of action arises them, the landowner, the petitioners, appellants herein. In the earlier writ petition,
So he is right in his submission.
yes,
My lord, what we paid is subject to, my lord, the outcome of the writ
ಆಯ್ತಲ್ಲ.
proceedings.
That-
Adana admele
that
immediately
case
we
was
filed a writ
decided.
appeal.
That
Writ ap-
case was decided.
Yes, ma'am. Not on the point, my lord, where, my lord, we had challenged on 2 other grounds. The grounds which were heard at my lord principal bench was only with regard to constitutional validity of my lord the provision. My lord, with regard to power of my lord the state to impose such fee. But here, my lord, we have, my lord, not only challenged that, we have also challenged on the ground that, my lord, there is no rationality. There is no, my lord, corresponding rules how to this amount has to be assessed. And we have also contended there are no lakes in this part because, my lord, 18A, when, my lord, such cess to be collected, it should be beneficial to, my lord, the owners of the land. When there are no lakes in this part of the area, that is not beneficial to the part of people of this area. Such imposition of cess unilaterally throughout the state is illegal. These three grounds, my lord, we have urged. Insofar as first ground, my lord, the principal bench, my lord, it was decided. Relying on that, my lord, our case also been disposed. Therefore, my lord, we have specifically, my lord, made them as a ground. One is, my lord, it was exceeding more than 30% of the market value of the land itself, which could not be, my lord, by way of additional fee or by way of a cess. That is one ground. Second ground, there are no rules framed, my lord, for assessing how, my lord, it has to be done. In the meanwhile, now, my lord, the state government, my lord, considering that there was some mistake in the earlier proceedings, they have formulated the rules and they have replaced the earlier provision. Therefore, my lord, now, my lord, the authority cannot say they were paid under the earlier proceedings. Now that provision itself is not there. The authority cannot hold back, my lord, the amount. The amount which was paid, that itself is been taken away. Now, my lord, it has been replaced. What is the replaced provision is by way of a substitution. Therefore, the amount which could be imposed is under only Rule 37A, which is now incorporated. It was under consideration, judicial consideration, and, my lord, it was also consideration before, my lord, the legislature, which has rightly considered it. Now, my lord, we have what excess amount we have paid, that is the only, my lord, refund we are not saying, my lord, this even 60,000 what is been done now is incorrect, because our grievance has been resolved now by virtue of, my lord, the amendment by way of substitution. Therefore, excess payment which has been, my lord, withheld by the authority requires to be, my lord, given back to, my lord, the beneficiaries.
You had a very valid point in saying in our area, there are no lakes.
No lakes.
To be rejuvenated. So therefore, it could not have been
Imposed.
Blanket order.
Yes.
Imposing this prescription throughout the state.
Throughout.
They should have considered
Our point number
the imposition only after ascertaining that such lakes are existing and or new lakes are being developed. ಹಂಗ್ ನೋಡಿದ್ರೆ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಪ್ಲೈ ಆಗಲ್ಲ ನಿಮಗೆ. Not apply.
Agadill.
Why are you agreeing for this 60,000?
No, my lord, entire layouts are been formed. We have committed with, my lord, the third parties, my lord. Therefore, my lord, this requirement is there. Therefore,
you have gone ahead now.
Yes, that is the reason, my lord, we are only seeking for a refund, whatever is, my lord.
Nodri, if they still argue, I think they have a valid point that has not been considered by the learned single judge.
At that time, this was not available, my lord. At that time of
Their original contention is
the availability of lakes.
So,
My lord, my lord, authority, Gulbarga development, urban development authority pertains to entire Gulbarga region, my lord. Your lake alle ಮಾಡಬೇಕು ಅಂತನಿಲ್ಲ. My lord, all the lakes.
There are no lakes ಅಂತ ಅವರು ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ಇದಾವೆ. I will produce, my lord. I will produce the maps. ಎಷ್ಟು ಇಲ್ಲಿ ಕೆರೆಗಳು ಎಷ್ಟಿದಾವೆ ಏನು ಅಂತ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಇದೇನ್ರಿ ಮ್ಯಾಪ್ ಇದೇನ್ರಿ?
Only one kere ಅದು ಶರಣಬಸಪ್ಪ lake, my lord, which is
ಅಷ್ಟೇ ಯಾವ್ದೋ ಒಂದೇ.
ದೇವಸ್ಥಾನ ಎದುರುಗಡೆ ಕೊಡಿ. That is given to the horticulture department. Horticulture and fisheries.
There is no scope for, my lord, developing a new lake. This is lake rejuvenation. It has to be an existing lake.
ಎರಡೇ ಇರೋದು. ಎರಡಿದೆ. ಒಂದು ಶರಣ ಬಸವೇಶ್ವರ ಲೇಕ್, ಇನ್ನೊಂದೇನೋ ಪಾಂಡ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಪಾಂಡಿಗಿಲ್ಲ.
ಎರಡೇ ಇರೋದು.
ಪಾಂಡಿಗಿಲ್ಲ.
ಹಾ?
ಪಾಂಡಿಗಿಲ್ಲ. Only lake.
But it's substantially big only. Although they have shown it as a pond. There are, even in terms of this map, there are two lakes.
ಅದನ್ನ ಹಾರ್ಟಿಕಲ್ಚರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಗೆ ಸರೆಂಡರ್ ಮಾಡ್ಬಿಡಿ. This urban development authority is not holding this Shanbasappa lake.
It's not who is maintaining it, adalla. See, whether it is maintained by horticulture department or by the urban development authority, that is not relevant. They may pass it on to the horticulture department. There is power, the delegation powers ಇದೆ ಅಲ್ಲಿ.
Horticulture and Fisheries Department, that is one of the ground I have heard.
Fix the rate.
Exceed 15% of the total. 18A ದಲ್ಲಿ sub clause 5 ಏನು ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, along with this 18(1)A. The all entire cess together should not exceed 1/10 of the market value of the market value of the property ಅಂತಿದೆ.
ಯಾವುದು ಇಲ್ಲಿ
18A sub clause 5 ಎರಡು ಒಂದೇ ಸಲ ಬಂದಿದೆ under same amendment. ಏಟೀನ್ ಎ sub clause 5 Roman 5 1 sub clause 5 ಅದನ್ನ ಈಗ ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ
5 18A
ಹಾ
1 Roman 5
ಹಾ
ಅದ್ರ ಕೆಳಗಡೆ
ಡಿಲೀಟ್ ಆಗೋಗಿದೆ.
ಹಾ ಈಗ ಡಿಲೀಟ್ ಆಗಿದೆ. ಅವಾಗ ಅದನ್ನು ಹಾಕಿದ್ರು, ಸೆಸ್ ಫಾರ್ ದ ರಿಸರ್ವೇಶನ್ ಆಫ್ ಲೇಕ್ ಆರ್ ವಾಟರ್ ಬಾಡೀಸ್ ಅಂತ ಮಾಡಿದ್ರು ಅಲಾಂಗ್ ವಿತ್ 18A. ಅದನ್ನ at such rates but all above levies together not exceeding 1/10 of the market value of the land or building as may be prescribed. So this land value of the market value of the land, the entire cess which could be imposed by the authorities should not exceed 1/10 of the market value. Here the value of the land itself was 2 lakhs, 3 lakhs was the market value of the properties when these properties have been purchased by these developers. Now this imposition of unilateral 1 lakh rupees was exceeding more than 35 to 40%. That was also without any rules. Corresponding rules irlilla avaga. For the first time this rule 37A has been inserted by virtue of the substitution. Avaga rule 37A irlilla.
ನೋಡ್ರಿ, you please convey all this
Please,
to the government.
Please.
Now they'll be happy if you confine it to 60,000 per lakh per acre. Otherwise, we'll have to consider the validity itself.
We have gone a step ahead and
When specific grounds are raised, which are unique to a planning authority, and if that is not considered, then we are required to reconsider that. They have raised a ground that nammalli yavadu lakes illa andu. Even if you contend that there are 2 lakes, when compared to what we find in Bangalore. In Bangalore, there are thousands.
ಇವಾಗಿಲ್ಲ ಅಲ್ಲ.
Even now, there are more than hundreds.
Yes, yes.
That you cannot disregard such contention. Instead of that, it is better to take instructions. Whether it can be restricted to 60,000, they'll also be happy.
I will take instance.
ನಮಗೆ refund ಇಲ್ಲ, adjust ಮಾಡಿದ್ರು ಸಾಕು ಸ್ವಾಮಿ. We have given that proposal also. In the event when we next time when we make an application, adjust ಮಾಡಿದ್ರು ಸಾಕು, ನಮಗೇನ್ refund ದುಡ್ಡೇ ಬೇಕು ಅಂತೇನಿಲ್ಲ.
We will make it a little easier for you. We will record all this submission.
Amended copy of
ಇದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ.
Allah, we will record all this submission and then request you to take instruction from the government. Purple.
Very important.
Even if, my lord, this provision is held to be, my lord, constitutionally valid, but the provision itself makes a proviso or an exception saying that, my lord, you can impose 1 lakh if it is below, my lord, 10% of the market value. If it is more than 10%, you will have to come down to 10%. All cesses and levies together cannot constitute.
How is it that they have removed that clause 5, subclause 5?
By virtue of amendment now.
Why?
Along with this amendment, they have removed now.
So this
Huh?
ಅದನ್ನ ಸೆಸ್ ಅಂತ ತೆಗೆದುಬಿಟ್ಟು ಓನ್ಲಿ ಅಡಿಷನಲ್ ಫೀಸ್ ಅಂತ ಇಟ್ಟಿದ್ದಾರೆ. Earlier it was both fee, additional fee as well as cess. So cess could not have exceeded 10% of total market value, which was going against them. Therefore, now they have removed that clause 5. And now only, my lord, 18(1)(a) has been retained.
they go by, my lord, the argument that, my lord, this was the law as on the date of, my lord, imposition. Then, my lord, these restrictions also will come into play, my lord, for them. They cannot cross, my lord, cesses and levies together cannot cross, my lord,
1/10.
the market value. It will be, my lord, lesser than what we are now agreeing on.
So ಹೆಂಗ್ ಹೋದ್ರೂನು ಕಷ್ಟ ಆಗುತ್ತೆ ನಿಮ್ಗೆ. By amending, you tried to take away the defect that you found earlier. 1/10 ಗಿನ್ನ ಜಾಸ್ತಿ ಎಕ್ಸೀಡ್ ಆಗಬಾರ್ದು ಅಂತ ನಿಮ್ ಪ್ರಾವಿಷನ್ ಇತ್ತು.
ಮೊದ್ಲಿತ್ತು, ಹೌದು.
ಈಗ
ಹೌದು.
when you found that these are exceeding 10%, now you remove that clause and you put it as additional fee in 18(1)(a). If so, their argument is, if you feel that by amending the provision and deleting subclause 5, that provision is no more available for them. The same argument they will put against you, that by amending it, you can't give a retrospective effect to that. So it has to be read as it was existing when this provision was made applicable to them.
I am appearing for development, urban development authority, government, my friend will instruct.
So, my lord, will get the
Perfect.
instruction, my
The
lord. This-
government should answer all that because the
Yes.
very provisions are under challenge.
It is the contention of the learned counsels for the appellants that subsequent to filing the writ appeals, the relevant provisions under the Karnataka Town and Country Planning Act of 1961 have been amended. Stop. It is pointed out that subsection 1(a) of section 18 has been amended with effect from 10/9/2015, removing the prescription of rupees 1 lakh per acre. 1 lakh per
1
acre.
lakh per acre.
And substituting the words inward commercially prescribed fee.
Additional.
Stop. It is pointed out that the corresponding provision in the rules have also been amended. In Rule 37 capital A of the Karnataka Planning Authority Rules, 1965. And in table Roman 3, the additional fee for grant of permission for approval of layouts or for development have been prescribed.
This was not there earlier.
Full stop. it is submitted that now a distinction has been made between the local planning authorities within Bangalore metropolitan region irrespective of population when compared to the local planning area which have different population. Full stop. The fee varies from local planning area with a population of less than 20,000, where fees of ₹3 per square meters are prescribed. And further ranges between ₹5, ₹10, ₹15 and ₹20. Full stop. The Gulbarga Development Authority falls under serial number 3, which has a population of more than 1 lakh but less than 10 lakhs. And the prescribed fee is ₹15 per square meters. Full stop. With this change in the provision, according to the calculation of the appellants, the prescribed fee would be ₹60,000 per acre. Full stop. Next para. Learned counsels would also point out that one of the legitimate grounds that have been raised by the appellants, which has not been considered by the learned single judge, is that question of levying lake rejuvenation fee would arise only if there are existing lakes within the master plan area which require rejuvenation. Full stop. It is submitted that even according to the master plan of Kalaburagi, there is only one lake and another small pond. Full stop. Therefore,
Substitution. By way of substitution.
the blanket prescription of lake rejuvenation fee is sought to be challenged on the ground that there is no intelligible differentia. Next para. It is in this background that the appellants are now contending that they would be satisfied if the government would accept the government would accept the fee at the rate of ₹60,000 per acre. And adjust the fee already paid by the appellants. Full stop. Next para. learned government advocate is hereby directed to secure instructions from the Principal Secretary, Urban Development Authority, having regard to the contentions made on behalf of the appellants. Full stop. Next para. Release this matter on 25th of November.
Please.
A copy of this order shall be served on the learned government.
Please.
PL number 21, Manvendra Reddy.
File necessary applications to bring the legal representative on record.
You filed application.
Yes, my lords.
Respond number 1A.
Yes, my lords.
Notice order ಆಗಿಲ್ವಾ?
No, no, no.
Huh?
Taken. Yes, Agila.
Take instruction.
ಆಗಿಲ್ಲ.
Let the notice be ordered, my lord. I'll take instructions, my lord. If I have instructions, I will straight away appear and inform him. I'll take notice, my lord.
Huh?
I'll take notice for the LR's, my lord,
Learned
the
Counsel
application.
Shri Harshavardhan or Mali Patil accepts notice on behalf of the proposed legal representatives of deceased respond number
1A.
R1A. Full stop. Learned Counsel would further submit that the application may be allowed to enable the legal representatives to come on record. Stop. Next para. Accordingly, IA number 1 of 2024 is allowed while condoning delay in filing the application. Full stop. Learned Counsel for the appellant is directed to carry out the amendment in the cost title.
Please.
And furnish amended cost title within a period of 1 week from today.
Please.
Yes.
Obliged.
CL number 22, additional government advocate.
These matters, my lord.
Huh?
Patch up matters is listed tomorrow, my lord. This is behind 120 days delay.
List this matter tomorrow.
Please.
Release this matter tomorrow.
CL number 23, Siddharuda B. Pujari.
My lord, the petitioner challenging the order passed by the.
A previous matter, did we say about that this one? That it also prescribed that it should not exceed 1/10. ಬರ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅಲ್ಲ ಯಾರು ತಗೊಂಡ ಡಿಕ್ಟೇಷನ್ ನೀವೇ ತಗೊಂಡಿದ್ದಾ ಅದೇ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟ್ರ್ ಲೇಕ್ ರಿಜ್ಯುವಿನೇಷನ್ ನೀವೇ ತಗೊಂಡಿತ್ತಾನೆ it is also contended by the appellants that
18A.
In terms of the amendment brought to section 18 and 18A of the Act Common 1961. In terms of Act 6 of 2012. The amended section 18A imposed a ceiling that the collection of cess and surcharge may be levied, but they together should not exceed 1/10 of the market value of the land or building as may be prescribed. Full stop. It was therefore contended by the writ petitioners that the market value of the lands in the year 2012-13 was around rupees 1 lakh per acre.
2 to 3 lakhs.
2 to 3 lakh.
Avaga.
3 lakh house, 100.
2 to 3 lakhs per acre.
Area.
And the prescription of rupees 1 lakh would exceed 1/10 of the market value by itself.
Some cases it is double the market.
Full stop. If the lake rejuvenation fee of rupees 1 lakh is added on to the other levy, such as water supply scheme, ring road, slum improvement, mass rapid transport system, etc., would all be beyond 50% of the market value. Full stop. It appears that the state government realized this aspect of the matter and made further amendments by Act 38 of 2015 with effect from 10/9/2015, thereby deleting subclause 5 of subsection 1 of section 18A pertain to the lake rejuvenation fee. Full stop. The learned councils would therefore contend that if such deletion, by such deletion, the state government wants to save the lake rejuvenation fee, which admittedly exceeds 1/10 of the market value. Then similar protection should be given to the appellants herein in respect of the amended provision which prescribes the fee in terms of table 3 of section rule 37A in terms of the amendment which came into effect from 10/9/2015. ಅದನ್ನು ಸೇರಿಸ್ಬಿಡಿ. Yes. Yes, Parire.
CL number 23,
Yes.
My lord,
Garuda B. Pujari.
the final seniority list has been published, my lord. By the final seniority list has been published, my lord. My name is, my name found a place in the seniority list, my lord. And only there is 4 posts of vacant posts, my lord, for promotion are available at the time of granting the promotion to the inspectors. And my lord, the DPC met the meeting and considered the promotions and found that I was facing departmental inquiry. In the sealed cover, my name is kept in the sealed cover and given the promotion to the 3 persons. my lord. Annexure A3 is the promotion order, my lord. Page 56. This matter has to be heard, my lord.
We have noticed in our order dated 22/11/2023. 22/11/2023 order note.
It is a reserved post, my lord.
22/11/2023. So we have stayed the impugned order of the tribunal
Yes.
by this order.
Yes. Your lordship, my lord, this on court, my lord, 16/2/2024, my lord, directed us to get the instruction regarding the provision, my lord, 32 and 42. Promotion, my lord, now, my lord, instruction is received, my lord, I'll file the statement of objection, my lord. Detail, my lord. Lordship, have it, this one for hearing itself, my lord. My lord, already promotion order has been passed by the respondent, my lord. Promotion order has been passed due to the order passed by the tribunal. The order is not issued to the petitioner, my lord. Here, my lord, I produced the documents to show that
They have passed a favorable order.
by the government, my lord.
Favorable order has been passed in your favor.
Yes, my lord.
Huh?
Yes.
Then why are you not implementing that?
Annexure A3 is the order, my lord. Proceedings of the DPC committee and promotion order also passed. This matter is covered by the order of this honorable court, my lord. Sorry, sir. Late. Perspective.
Specific directions were given on 16/2/2024. You have still not got instruction.
Now received my lord instruction, my lord.
ಏನ್ ಹೇಳ್ತಾರೆ?
This is the pass on.
Application was filed by whom? By you or?
By me.
Fifth respondent.
You had filed the application.
yes.
Your application is allowed.
Yes,
Partly allowed.
application is partly allowed.
Partly allowed.
Partly allowed.
Ah.
My lord, here what had happened, my lord? My lord, admittedly, my lord, I am senior. My lord, to the, my lord,
Sir, but it's also an admitted position that he belongs to scheduled caste community.
correct.
And that promotional post is to be given to a scheduled caste person.
In terms of roster, my lord, he comes, my lord, his promotion has to be taken
Correct.
first. And at that point of time, my lord, he was,
It was a D.
there was a D.
ಆಯ್ತು.
And my lord,
That concluded.
that concluded into censure.
ಹೌದು.
That, my lord, censure, my lord, the effect of the censure, my lord, that he has to be promoted prospectively.
Huh?
The effect of censure, my lord, is that, my lord, he has to be, my lord, promoted prospectively.
How do you say?
My lord, the decision of the Honorable Supreme Court, my lord, wherein the tribunal has considered. May I produce?
Para six, my lord.
Lordship.
Para six. Para six.
Now, my lord, there is no bar, my lord, for him to be also promoted. Para, my lord,
Six.
tribunal, my lord. Tribunal's order, my lord.
Para six, my
Para
lord.
six.
Page number
Recording
35.
of censure therefore is a blameworthy factor. A bare reading of rule 3.1 as noted above makes the position clear that where any penalty has been imposed, the findings of the sealed cover are not to be acted upon and the case for promotion may be considered by the next DPC in the normal course.
Yes.
What is that rule 3.1 they are talking of?
My lord, rule 3.1, my lord, in the circumstances of that case.
Ade a case.
Yes, my lord.
So therefore, there should be similar provision here.
A similar provision.
Yen provision.
My lord, that is, my lord, the penalty, my lord, rule 8.
Extract ಮಾಡಿದಾರಲ್ಲ.
Yes.
ಅಲ್ಲೇ previous ಇದರಲ್ಲಿ pages ಅಲ್ಲಿ extract ಮಾಡಿದ್ದಾರೆ.
Extract ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
Point out.
Yes, my lord. Here, my lord, in terms of, my lord, the central government rules and the, my lord, the CCA rules of the state also, my lord, all the punishments, my lord, enumerated are the same, my lord. And even, my lord, of that, the dismissal, my lord, reduction, and, my lord, the censure, warning, my lord, all those things. Now, my lord, insofar as censure is concerned, my lord, it is not defined, my lord, in either of these rules, my lord. Now, my lord, the Honorable Supreme Court, my lord, in this case, my lord, A.N. Mohanan's case, my lord, has held, my lord, that censure is a blameworthy factor. And, my lord, it, my lord, ends in the same day when it is imposed. But when it comes to promotion, my lord, that person becomes eligible prospectively, my lord, for promotion. That is a clear, my lord, the principle, my lord, laid down, my lord, by the Honorable Supreme Court.
Sir, it followed a particular rule. So therefore, we are asking you, what is this rule 3.1 that was noticed there in that case? And whether similar provision is here in our rules, please point out.
Rule 6 of the KSP DP rules. Rule 6 of the KSP DP rules.
Extract ಮಾಡಿದಾರಲ್ಲ ಇಲ್ಲಿ.
ಇದರಲ್ಲಿ DP rules extract ಅವರು ಮಾಡ್ಲಿಲ್ಲ.
ಹಾ.
My lord, lordship may kindly see.
ಕೊಡಿ ಇದ್ರೆ ಕೊಡಿ. Let us see.
3-1.
That is, my lord, ಇದರಲ್ಲಿ PPP rules extract ಮಾಡಿದ್ದಾರೆ. My lord, may I
Page number 32.
page, my lord, PPP rules. Page number 465. 465.
As per government circular dated 6/4/2010 at annexure A5, he is eligible for promotion prospectively but not retrospectively.
Yes.
Yavadadu circular?
That is, my lord,
Annexure A5.
my lord, page 63A in the present petition, my lord. Page 63, 62, 63. Type copy, my lord, 63A.
It has been wrongly read.
Please,
Please read it.
please.
Please read the circular.
ಸರ್ಕಾರಿ ನೌಕರ ವಿರುದ್ಧ ಇಲಾಖಾ ವಿಚಾರಣೆ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆಗಳು ಪ್ರಾರಂಭವಾಗಿ ಅಂತ ಇಲಾಖಾ ವಿಚಾರಣೆ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆಗಳು ದಂಡನೆಯಲ್ಲಿ ಪರ್ಯಾಯವಾಸನೆಗೊಂಡಲ್ಲಿ ಆ ದಂಡನೆಯ ಜಾರಿಯಲ್ಲಿರುವ ಅವಧಿಯಲ್ಲೇ ಅಂತ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮುಂಬಡ್ತಿ ನೀಡಲು ಆಸ್ಪದವಿಲ್ಲವೆಂದು ಉಲ್ಲೇಖಿತ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಹೇಳಲಾಗಿದೆ. ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಣ ಅಪೀಲ್ ನಿಯಮಗಳು 1957ರ ನಿಯಮ 8ರ ಅಡಿಯಲ್ಲಿ ನಮೂದಿಸಿದ ದಂಡನೆಗಳ ಪೈಕಿ ವಾಗ್ದಂಡನೆಯು ಸೆನ್ಶೂರ್ ಯಾವ ಅವಧಿವರೆಗೆ ಜಾರಿಯಲ್ಲಿರುತ್ತೆಂಬ ಬಗ್ಗೆ ಅನೇಕ ಇಲಾಖೆಗಳು ಸ್ಪಷ್ಟೀಕರಣವನ್ನು ಕೇಳಿವೆ. ಈ ವಿಷಯವನ್ನು ಸಿಯಾಸು ಇಲಾಖೆ ಪರಿಶೀಲಿಸಿದೆ.
ಈಗ ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸ್ವಲ್ಪ ಸ್ಲೋ ಆಗಿ ಓದಿ
ಪ್ಲೀಸ್.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 2.
ವಾಗ್ದಂಡನೆಯು ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವಾ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಣ ಮತ್ತು ಮೇಲ್ಮನವಿ ನಿಯಮಗಳು 1957ರ ನಿಯಮ 8ರ ನಿಗದಿಪಡಿಸಿದ ಅತ್ಯಂತ ಲಘು
ದಂಡನೆಯಾಗಿದೆ. ಅಂದರೆ ಸರ್ಕಾರಿ ನೌಕರರ ವಿರುದ್ಧದ ಆರೋಪವು ಗಂಭೀರ ಪ್ರಮಾಣದ ಆರೋಪವಲ್ಲದಿದ್ದಲ್ಲಿ ಮತ್ತು ಸಾಬೀತಾದ ಆರೋಪದ ಗಂಭೀರತೆಯನ್ನು ಪರಿಗಣಿಸಿ ಅತ್ಯಲ್ಪ ಮಟ್ಟದ ದಂಡನೆಯನ್ನು ವಿಧಿಸಬೇಕಾದ ಸಂದರ್ಭಗಳಲ್ಲಿ ವಾಗ್ದಂಡನೆಯನ್ನು ವಿಧಿಸಲಾಗುತ್ತದೆ. ಈ ದಂಡನೆಯು ಜಾರಿಯಲ್ಲಿರುವ ಅವಧಿ ಬಗ್ಗೆ ನಮೂದನೆ ಇರುವುದಿಲ್ಲ. ಈ ದಂಡನೆಯ ಸ್ವರೂಪದಿಂದಾಗಿ ಇದು ಯಾವುದೇ ಅವಧಿಯವರೆಗೆ ಜಾರಿಯಲ್ಲಿರುವುದಿಲ್ಲ. ಅಂದರೆ ಇದನ್ನು ವಿಧಿಸಿದ ತಕ್ಷಣದಿಂದ ಅದು ಮುಕ್ತಾಯವಾಗುತ್ತದೆ.
Yes, yes.
ವಾಗ್ದಂಡನೆಯು ಅದನ್ನು ವಿಧಿಸಿದ ದಿನಾಂಕದ ನಂತರ ಜಾರಿಯಲ್ಲಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ವಾಗ್ದಂಡನೆಯನ್ನು ವಿಧಿಸಿದ ದಿನಾಂಕದ ನಂತರ ಸಂಬಂಧಿಸಿದ ನೌಕರರ ಪ್ರಕರಣವನ್ನು ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ ಎಂದು ಸ್ಪಷ್ಟೀಕರಿಸಿದೆ.
This is, my lord, in terms of.
When was it? The very moment it is imposed, it is finished.
It is finished. Yes, my lord.
Therefore, it has no effect at all
But, my lord, the
on the
Supreme,
promotion.
my lord, but Supreme Court, my lord, says, my
That
lord,
is why we said it is considered in terms of rule 3.1 there.
my lord, is similar.
Therefore, you'll have to point out what is that 3.1 that was found there and whether similar provision is here. Please point out.
Please, my lord. My lord, KSP DP rules, my lord, rule 6, my lord.
Yes. ಅಷ್ಟು ಇದ್ದಿದ್ರೆ ಕ್ಲಿಯರ್ ಆಗಿದ್ದಿದ್ರೆ ಈ ತರ ಸರ್ಕ್ಯುಲರ್ ಯಾಕ್ರೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ?
Andre circular based on, my lord, this,
My lord,
Mohanan's case, my lord. Mohanan's case ಆದ್ಮೇಲೆ ಇದು circular issue matter. Based on that, my lord. My lord, here,
ಆಯ್ತು. ಇದು 2010 ಅದು.
2010, my lord.
The circular was issued in the year 2010.
ಇದು 2007 judgment.
ಅದು?
Judgment is 2007. This,
That judgment, sir, again, I'm at the cost of repetition, I'm saying it is based on a particular rule.
yes, ma'am.
It is not clear as to what is that rule here.
Yes, ma'am.
If you have the complete judgment, you please give it.
Uh,
ಆಮೇಲೆ similar provision you'll have to point out.
yes, ma'am.
First you'll have to point out what was the provision that was considered,
Yes, ma'am. Please.
that judgment. If you have a complete copy of the judgment, you please give.
My lord,
I
judge,
have extracted that rule 3.1.
no, my lord.
See what is that?
Rule 3.1, my lord, I have not extracted.
ನೀವಲ್ಲ ರೀ ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಇದರಲ್ಲಿ. Lordship, I have passed on. my lord.
ಇದೇನಾ?
Yes, I have passed.
This is the judgment.
Yes.
Huh?
Yes, my lord. Yes, ma'am.
What was relied upon? This is the judgment.
This is, yes, my lord. This is the,
What is that 3.1?
my lord, that is, at, second
Rule
page, my lord,
3 and 3.1 read as follows. Yes.
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 Rule 3. On the conclusion of the disciplinary case, criminal prosecution, which results in dropping of allegations against government servant, the sealed cover or covers shall be opened. In case the government servant is completely exonerated, the due date of his promotion will be determined with reference to the position assigned to him in the findings kept in the sealed covers, and with reference to the date of promotion of his next junior on the basis of such position. The government servant may be promoted if necessary by reverting the junior most officiating person. He may be promoted notionally with preference to the date of promotion of junior. However, whether the officer conveyed will be entitled to any arrears of pay for the period of notional promotion preceding the date of actual promotion, and if so, to what extent, will be decided by the appointing authority by taking into consideration all the facts and circumstances of the disciplinary proceeding, criminal proceeding, prosecution. Where the authority denies arrears of salary or part of it, this,
ಅದಲ್ಲ ಇಲ್ಲ.
ಇದರಲ್ಲಿ ಇಲ್ಲ.
Which is.
ಅದರ ಮೇಲೆ ಇದೆ, rule 3.1.
ಹಾ.
If any penalty is imposed on the government servant as a result of the disciplinary proceedings, or if he is found guilty in the criminal prosecution against him, the finding of the sealed cover shall not be acted upon. His case for promotion may be considered by the next DPC in the normal course and having regard to the penalty imposed on him. Though learned counsel for the respondent submitted that awarding of censure does not amount to awarding of penalty, the same is clearly untenable. In Union of India, etc. versus KV Janki Raman, etc. At page number 2, at 2017, it was held as follows. May I read more? The census is relevant. We are therefore broadly in agreement with the findings of the tribunal that when an employee is completely exonerated, meaning thereby that is not found blameworthy in the least and is not visited with the penalty even of censure, he has to be given the benefit of the salary of the higher post along with the other benefits from the date on which he would have normally been promoted, but for the disciplinary criminal proceedings. However, there may be cases where the proceedings where the disciplinary or criminal are, for example, delayed at the instance of the employee or for the clearance in the disciplinary proceedings or acquittal in the criminal proceedings is with benefit of doubt or on account of non-availability of evidence due to the acts attributable to the employee, etc. In such circumstances, the concerned authorities must be vested with the power to decide whether the employee at all deserves any salary for the intervening period, and if he does, the extent to which he deserves it. Life being complex, it's not possible to anticipate and enumerate exhaustively all the circumstances under which such consideration may become necessary. To ignore, however, such circumstances when they exist and
laid down an inflexible rule that in every case, when an employee is exonerated from disciplinary criminal proceedings, he should be entitled to all salary for the intervening period is to undermine discipline in the administration and jeopardize public interest. We are therefore unable to agree with the tribunal that to deny the salary to an employee would in all circumstances be illegal. While therefore we do not approve of the said last sentence in the first paragraph after clause 3 of the said memorandum, wherein but no arrears of pay shall be payable to him for the period of notional promotion preceding the date of actual promotion. We direct that in place of this said sentence, the following sentence be read in the memorandum. However, whether the officer concerned will be entitled to any arrears or pay for the period of notional promotion preceding the date of actual promotion, and if so, to what extent will be decided by the concerned authority by taking into consideration all the facts and circumstances of the disciplinary criminal prosecution. Where the authority denies the arrears of salary or part of it, it will record its reasons for doing so. Now, my lord, here it comes. Awarding of censure. Therefore is blameworthy factor. A bare reading of Rule 3.1 is noted above makes the position clear that where any penalty has been imposed, the findings of the.
Now you pointed to similar provision in our.
Please, my lord.
3.1 ಇದೆಯಲ್ಲ ಈ ತರ similar provision where we have.
Please note, if lordship my lord, short accommodation my lord, I will find out. ಯಾಕಂದ್ರೆ ನಾನು ಅದ್ರ ಬಗ್ಗೆ ನಾನು ನೋಡಿ.
See, this is what we do.
ಅದು
don't analyze what is the basis of the judgment of the Supreme Court. They simply say, ಅಲ್ಲಿ ಹೇಳಿದರೆ censure also would amount to punishment and therefore you can deny. What was considered in Janaki Raman's case was the right to seek arrears of payment, arrears of salary. That was what was considered in Janaki Raman's case. And this judgment in Mohanan's case, though it is regarding censure.
Yes, ma'am.
But it is based on that particular provision, Rule 3.1.
My lord, once.
Therefore, we'll have to see whether similar provisions are there in our rules.
I will, my lord, point out that, my lord, and even in Janaki Raman's case, only a part of it has been extracted in this, my lord, judgment. Last para of
Janaki Raman's case may not be of great use for us because, again, we can see that it will all be based on a particular provision of law.
Yes, ma'am.
So therefore, we'll have to find out whether similar provision is there. So if you are able to point out there is something like Rule 3.1 in our provision, then we can hold it against the petitioner.
Yes, for a short accommodation, but I will produce.
In this case, my lord, it is the 4 posts were vacant, my lord. Two posts for general merit candidate.
ಅದೆಲ್ಲ ಆಯ್ತು ಗೊತ್ತಾಯ್ತ್ರಿ. It is this judgment of the tribunal is based on a judgment of the Supreme Court. Please understand. And that is based on a particular provision. This is how you have to analyze.
But that
simply by you are saying, they have considered the case of censure, and therefore it can be made applicable. Angala ododu. May be correct. That was also a case of censure, but it is based on a particular provision. So you will have to point out, yes, similar provision is there in our rules. If you point out, then accept it.
Yes, I will.
Berkeley. Since the tribunal has based its opinion on a judgment of the Honorable Supreme Court in the case of Union of India and others versus A.M. Mohanan. And we find that in the case of A.N. Mohanan, the Supreme Court considered the case having regard to a particular rule, namely Rule 3.1. of the official memorandum the learned government advocate and learned counsel for the private respondent are required to point out whether similar provision as in a rule 3.1 in the OM is found in the rules applicable to the parties here.
Yeah.
Next para. Release this matter. ಆದ್ಮೇಲೆ ಇವ್ರು ಏನಾದ್ರು ಅದನ್ನ ಅಮೆಂಡ್ ಮಾಡಿ ಏನೋ ರೂಲ್ಸ್ ತಂದಿದಾರನೋ ಅದು ಇಲ್ಲ ಅಂತಂದ್ರೆ then we'll have to consider this also. Here it is very clear. They are of the opinion that no, the moment it is passed, it loses. ಅಷ್ಟೇ ಮುಗೀತು. We do not know. If they are able to see this, tribunal has based its opinion on this judgment. Yes. But we find that in this judgment, they have placed reliance on a particular rule. So if similar rules are pointed out, we can accept the judgment of the tribunal. Yes, it is based on similar rule only. Otherwise, no.
My lord, it is moreover, it is a reserved post, my lord. General candidate cannot claim.
I do agree, my lord. I do agree.
All that is accepted. The question is passing of an order of censure would amount to imposing punishment, because the other provisions would clearly say if you are imposed punishment, then your claim for promotion can be considered only from the next DPC.
Yes, it is the next DPC only considered my case, my lord.
So the question now is whether censure in our rules can be considered as a punishment. Going by that circular, it is clear that it is not a punishment. If you go simply by the circular, then it will be in his favor.
Yes.
Because it is clarified by the government itself.
Yes. And my lord, now their submission, my lord, is that, my lord, in terms of the order of the KAT, that, my lord, prospective promotion, my lord, already that they have considered, and, my lord,
ಅದು ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
But his claim is regarding retrospective promotion.
And, my lord, still, my lord,
What he is claiming.
Still, my lord, the Supreme Court holds, my lord, that it's a blameworthy fact.
You went to the tribunal, isn't it?
Yes.
You went application.
My yes.
Which means the government granted him retrospective promotion.
No, my lord. What had happened, my lord? There were, my lord, 4 posts, my lord, for the post of assistant commandant. My lord, I was in the last, my lord, for consideration. My lord, 4th person. My lord, although other 3 persons, my lord, they were granted promotion regularly as assistant commandant. But when my turn came, my lord, in the same DPC, my lord, they, my lord, kept me under Rule 32 of KCSR, despite being holding that I am eligible in all aspects for promotion. But, my lord,
That is because
only for the reason, my lord,
that promotional post had to be reserved for a scheduled caste person.
My lord, but, my lord, here, my lord, when I'm in the zone for consideration for promotion, my lord, and I'm eligible, and, my lord, they ought to have granted me, my lord, for the simple fact, my lord, that he was facing disciplinary action. My lord, if, my lord, he is exonerated completely, yes, my lord, definitely, my lord, he would revert back, my lord.
What we are considering.
Yes, please, please.
Huh? You know, a realist. When will we have?
Needed. 5.6. Any date. 25.
ಅಷ್ಟು ದೂರ ಏನಕ್ರಿ 2 weeks ಆಗೋಗುತ್ತೆ. You are only required to point out whether similar rules are there ಅಷ್ಟೇ.
20th.
You can do it today itself.
20th.
20.
Release this matter on 20th of November. Yes.
Sir,
ನನಗೆ ಗೊತ್ತಿತ್ತು
ಕೊಡಿ.
ಹಳ್ಳಿ ಹೋಗ್ತದೆ ಅಂತ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇಲ್ಲ, ಸುಮ್ನೆ ಅದು. depot ಬಂದ.
ಇಲ್ಲ ಹುಡುಗ ಇದಂತೂ ಚಂದ್ರಕಾಂತ್ ಇದು ಇವ್ರಿಗೆ
ಸರ್. ಒಂದು 15 ನಿಮಿಷ ಲೇಟ್ ಆಗ್ಬೋದು. 15 ನಿಮಿಷ.
ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಈಗಿನ ನಾವು 23 ರಲ್ಲಿ ಇದೀವಿ, I mean 24 ಅಲ್ಲಿ ಸ್ಕಿಪ್ ಆದ್ರೂ ಆಗ್ತದೆ ರ್ಯಾಂಡಮ್ ಆಗಿ. ಯಾರಾದ್ರೂ ಸ್ಟಕ್ ಆಯ್ತಂದ್ರೆ ಆಗಲ್ಲ. Bill number 24, Ganesh Subhachandra Kalaburagi.
There was connected one matter.
Huh?
Connected matter, your lordship, which was pending before the honorable single judge. In this case, earlier date of hearing, the notice to the respondents were served, they didn't appear. So I submitted that one more matter is pending before the honorable single judge. Your lordship has directed whether they were appeared in that matter or not. But in that case also, your lordship, though notice were served, they remained absent. When I have submitted that before this honorable single judge, this matter is pending before the division bench.
Yes.
So order is passed on 29/10/2024, wherein the honorable court has directed to put up this matter before the honorable chief justice to tag that matter with this.
Aye.
Yes.
Learned counsel for the appellant submits that the learned single judge has passed an order on
29/10/2024
9/10/2024
in RFA.
appropriate directions at the hands of the Honorable Chief Justice to enable consideration of RFA number 20065 of 2024 along with this matter.
Yes.
Full stop. Next para. Office is directed to await the orders of the Honorable Chief Justice and thereafter list this matter along with RFA number so and so.
File FDP file. They filed FDP, your lordship.
Huh?
Final decree proceeding they have initiated, the respondents.
Partition suit.
Yes, yes. So we filed written statement
Ah.
to be unable to read the evidence, your lordship. So
Ah.
our contention is that some of the properties are my self-acquired properties.
Hmm.
So that aspect we were unable to prove before the trial court.
Hmm.
That evidence, opportunity to lead evidence on that aspect.
Hmm. The trial court is directed not to drop final decree without express orders of this court. Yes.
Seal number 25, Mahantesh Patil.
I'm appearing for the complaint, madam. I'm appearing for the complaint, madam.
Yes.
There is a direction to the respondent to consider the representation as a connection F and F1 within a period of 60 days. Madam, the respondents have not considered the representation.
Learned government advocate is requested to take this correspond number 3. Issue notice to response number 1 and 2. Learned counsel for the complainant is directed to serve a copy of the petition along with annexures on learned government. Notice returnable by 25th of November.
Seal number 26, Ratna N. Shivayodhana.
365 days delay in
My
filing
lords,
the appeal.
after disposal of the writ petition, my lord made a request to refund the amount along with the interest, my lords. They have refused to pay the interest, reasonable interest, my lord. They have requested me to take the entire amount along with the 5% of interest, my lord. Therefore, I may file this writ petition regarding the interest, my lord. There is a delay. I produced the documents which has issued by the Assistant Registrar of Cooperative Society, who is the recovery officer. They have participated in the auction and deposited the 22 lakhs 50,000.
You are the auction purchaser
Yes, my lords.
who was subsequently included
Uh,
in the
no,
writ petition.
but
Huh?
she was a party, my lord.
Other, you were subsequently included.
Yes, yes, my lords. The court has allowed the writ petition and directed them to pay the interest. Last may kindly see the operative portion of the order, my lord. And given the,
Dr. M.K. Qureshi,
yes, ma'am.
Mohammed Majid Qureshi. Response number 4 and 5. They are the writ petitioners.
Yes, they are the owners of the property, my lord. They have challenged the auction. And the auction was challenged, my lord. The learned single judge allowed the writ petition and directed to pay the amount, entire amount in 3 equal installments. In second, my lord, ink page 16. And third one, my lord, on completion of payment, amount paid by the auction purchase will be refunded with due interest thereon after expire of 6 months, since the auction purchase would still continue to have vested right over the auction properties on account of default, if any of the citizen. Therefore, the word used due interest, taking the advantage of this, my lord, the assistant registrar of court society, who is the officer of the recovery officer, has issued a letter that is produced at ink page 78 along with my IA. And I made a request to repay that amount along with the interest. Request letter is ink page 76, my lord.
What is the prayer in your appeal?
Appeal, my lord, to pay that amount along with
Modify the operative portion.
yes, ma'am.
Modify ಅಂತಂದ್ರೆ you have to go before the learned single judge only. How can we modify the order? Alva?
Yes.
If you are seeking modification of the order, then you have to go before the learned single
Yes,
judge. We will give a liberty then. Huh?
Only interest for.
Only 5%.
The repaying amount.
Yes, he is a auction purchaser. Liberty has been given to the writ petitioner. Now, the appellant is asking for certain modification in the order passed by the learned single judge. Huh?
Repay that interest.
Only by the learned single judge.
Yes.
Lordship, I appear for respondent number 3 bank. Today I have filed a wakalat on behalf of bank. Earlier, the court was ordered to take a notice to delete it. And my lordship, I want to bring a notice to this honorable court. By the order dated 23/2/2024, assistant registrar has passed the order by giving a 5% of interest in respect of due interest. So there was no clarification. The assistant registrar has been passed the order paying of 5%. So total to the auction
purchaser.
Order is passed, so they have to challenge this order if they want to increase interest rate, my lord.
Yeah, increase. You have received the entire amount. They collected the.
And my lordship, I'm for.
I raised the loan 14% interest for that amount. We have deposited 22 lakhs at the auction. I produced that bank statement also.
So that borrower has repaid the entire amount?
Borrower has repaid entire the amount, and the borrower has paid the 22 lakhs, whatever the auction purchaser, to the assistant registrar, and we have not received that amount to the bank. And subsequently, the order of the single judge, the assistant registrar respondent 2 has given a check with along with the interest. So far, we are not a recipient of the amount deposited by the auction purchaser bank. So bank here, my lordship, I want to convey this quote. So bank is not liable to pay the interest, my lordship, because the amount was with the assistant registrar. It never received in the bank's account. And assistant registrar and assistant registrar, as per the direction of single judge, the assistant registrar has paid from the treasury, from their account. And there is a document, my lordship.
Anyway, the prayer is to seeking modification.
Yes, I'll seek a modification.
Written only by the learned single.
I'll clarify that also in the before learned single, who has to pay the interest.
But ಅಲ್ಲಿ provision ಇದೆಯಮ್ಮ. Act ಅಲ್ಲಿ there is a provision regarding payment of interest. They can't go beyond that.
They can't kept that entire amount with them. They have to deposit in the bank.
ಅದೇ ಮಾಡ್ಬೇಕಾಗಿ.
Or ಮಾಡ್ಬೇಕಾಗಿತ್ತು. They have kept it in their custody. That is their fault. They can't do so. Otherwise, they would get the bank interest.
The prayer made in the writ appeal is to modify the operative portion of the order dated 28/7/2023. Passed by the learned single judge. Full stop. Therefore, comma, here of the considered opinion that the appellant should make such a prayer before the learned single judge. Full stop. Next para. Consequently, the writ appeal stands disposed of, reserving liberty to the appellant to file necessary application before the learned single judge, seeking modification of the impugned order.
Yes.
Ordered accordingly.
Serial number 27, SS Salani.
The delay of 34 days.
Huh?
It is a delay in filing. This is the fifth respondent. They have permitted the cart road to form the sites. Page G, page 45. The road, cart road, which passes through all these lands, they have taken inside and expanded it virtually on the road. The last portion they have made the sites. In the government, it's a cart road, it's public cart road. My land is the next to that, annexure model H page 46 may kindly be seen there. That's a cart road is shown. Though the order of the deputy commissioner is excluding that 4 guntas used for this, the cart road in that 102 survey number. ಅವ್ರು 9 ಮೀಟರ್ ಬಿಡಬೇಕಾಗಿತ್ತು, ಇದನ್ನ 5 ಮೀಟರ್ ತಗೊಂಡು ಇನ್ನು 4 ಮೀಟರ್ ಸೇರಿಸಿ ಅದನ್ನ they have made a cart road, and virtually the cart road they have made the sites, diverting the main road.
The petition is dismissed on the ground of delay and laches.
Delay.
Learned government advocate takes notice for response number
124. ಅಲ್ಲ urban development, assistant director of town and country planning.
Director.
124 of the government.
Issue notice to respond number 5. First of learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government.
Lord, may I request, they should not create a third party interest in the
First of all, your reputation has been dismissed on.
ಅಲ್ಲ ಆಗಿದೆ, ಬಟ್ ಅಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ್ರಂದ್ರೆ ಆಸ್ ಆಫ್ ನೋ ಆಗಿಲ್ಲ. ನಾನು ಕೇಳಿದ್ದೀನಿ. ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಈಸ್ ಆಸ್ ಆಫ್ ನೋ ದೇರ್ ಇಸ್ ನೋ.
Not now. Yes.
Number 28, Basuraja R. Mutt.
Respondent. ಇವರು ಬಸವರಾಜ್ ಆರ್ ಮಟ್ ನಾವು ಬಂದಾಗಿಲ್ಲ, ನಾನು ಕಾಣ್ಲಿಲ್ವಲ್ಲ.
ಇಲ್ಲ ಇದ್ರು ಸ್ವಾಮಿ, ಮಾರ್ನಿಂಗ್ ಇದ್ದು
ಬಂದಿದ್ದೀರಾ? ಹಾ, ಬಂದ್ರಲ್ಲ.
Calculation method, I will still entitle another 7,45,000. Income, it is a main error in holding that in tribunal. Every month 7,000 income tax has been deducted. That is wrong. Income tax 25,769 ಅಷ್ಟೇ ಕಟ್ ಆಗುತ್ತೆ. ಇನ್ ಮೈ ಸೆಕೆಂಡ್ ಗ್ರೌಂಡ್ ಆಫ್ ದಿ ಅಪೀಲ್ ಮೆಮೋ ಹ್ಯಾವ್ ಡನ್ ದಿ ತೋರಿಸಿದ್ದೀನಿ, ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿನಿ.
ಕಾಪಿ ಇಸ್ ಗಿವನ್
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್
ಹೌದು, ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಹಾ, ನಾನು ಇನ್ನ 7,45,008 ರೂಪಾಯಿ ಬರುತ್ತೆ ನನಗೆ.
ಪ್ಲೀಸ್.
ಕರೆಕ್ಟ್. Can be allowed.
Please. Allowed in part.
This 6% interest ಮಾಡ. ನಾ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿಲ್ಲ, ಅದು ಬರ್ದಿಲ್ಲ ಅಲ್ಲಿ.
In para.
Every month ಏನ್ ಮಾಡಿದಾರೆ 7,000 ತೊಗೊಂಡ್ರೆ that is wrong malad. That is in it.
Para 16 malad.
16.
Lord, that is exhibit P6, P8. Lord, that was showing that.
Respondent number 2 was argued that petitioners number 2 to 4 have attained majority. They are not dependents of the deceased. On perusal of it, declare that the petitioner are studying, hence contention is not accepted.
Next person.
Getting salary of 63,649.
In the month of the marriage, January 2003, exhibit
that the deceased was paying income tax of 7,532.
ಅದನ್ನ ಎವ್ರಿ ಮಂತ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ರಾಂಗ್ ಮಲಾಡ್. 25,000 ಬರುತ್ತೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ TDS ಕಾಪಿ ಹಾಕಿದಾರೆ ನನಗೆ, ಅದು ಪ್ರಿಂಟ್ಔಟ್ ತೊಗೊಳಕ್ ಆಗ್ಲಿಲ್ಲ ನನಗೆ. TDS ಪ್ರಕಾರ ಅವ್ರದ್ದು ಕಟ್ ಆಗದ ಸ್ಯಾಲ್ರಿ 24,400 ಕಟ್ ಆಗಿದೆ. ಆಕ್ಚುಲಿ ಇದು ನನ್ಗೆ 6,600 ರೂಪಾಯಿ ಲಾಸ್ ಅಲ್ಲಿ ಮಾಡ್ಕೋತಾ ಇದ್ದೀನಿ. ಬಟ್ ಮ್ಯಾಟರ್ ಬಂದಿದೆ, ಐ ಶುಡ್ ನಾಟ್ ಅವಾಯ್ಡ್ ದಿಟ್ ಮಲಾಡ್. ಐ ಆಮ್ ಸ್ಟಿಲ್ ಎಂಟೈಟಲ್ 7,45,008 rupees ಫಾರ್ ಅನೌನ್ಸ್ಮೆಂಟ್.
What is your submission?
My submission is that, Malad, every year, every month, 7,000 salary should, income tax should not be deducted in the claimant's deceased salary, Malad. Only, Malad, his yearly salary 65,649 into 12 ಮಾಡಿದ್ರೆ 7,63,088 ರೂಪಾಯಿ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಟ್ ಆಗಿ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್, ಇದು ಗ್ರೌಂಡ್ ನಂಬರ್ 2 of the my appeal memo. I have done the my calculation how to be has to collected in the income tax malad. ಅಲ್ಲಿ 25,769 ರೂಪಾಯಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ನಂದು.
We cannot do without looking into the records.
Yes, malad.
Will not be correct.
Yes, malad. Yes, malad.
Call for trial court records.
Please. Otherwise, malad, tomorrow HDFC is coming. It may be referred to local. ಅವ್ರು ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಅಲ್ಲೂ ನಾನು ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೆ.
ಮಾಡೋದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡೋದು ಬೇಡವೇನ್ರಿ?
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಪ್ಲೀಸ್.
Yes. ಇಲ್ಲ, ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ. ಮಂಜುನಾಥ್ ಮಲಯ ಶೆಟ್ಟಿ has taken notice.
I have filed without. Actually, this appeal was posted before the free conciliation, my lord. Where, my lord, we are negotiated, but that was not successful, my lord.
They have not given the approval. Approval ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ.
Meanwhile, my lord, I will file over.
It cannot be, it should not be done without looking into the record.
Please, my lord, please,
please,
please, please, my lord, yes.
What was the total income tax deduction?
Only 25,000 ಅಷ್ಟೇ ಆಗಬೇಕು.
ಎಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
Please. ಆಯ್ತು ಸ್ವಾಮಿ.
Cannot be done like this.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
Other two respondents
dispensation ಮಾಡಿ.
dispensation.
ನಾನು ಕೊಡ್ತೀನಿ, ಮೆಮೊ ಕೊಡ್ತೀನಿ. ಆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಕೊಡ್ತೀನಿ ಈಗ. I will give the memo.
Counsel Sri Manjunath Malaya Shetty has taken notice for respondent number 2. Full stop. Learned counsel for the appellants has filed a memo seeking dispensation of notice to respondent number 1 on the ground that respondent number 1 is the owner of the vehicle and liability has been fastened on respondent number 2. Full stop. Next para, at the risk of the appellants, notice to respond number 1 is dispensed.
Please. Yes.
Good job. Next para, call for trial court records.
Seal number 29, Sanjeev Patil.
Sorry, my lord, on behalf of Sanju Patil, I am appearing. My lord, claimant's appeal is there, my lord, he was seeking for enhancement. My lord, kindly issue notice, my lord.
Royal Sundaram,
Preeti Patil is there.
learned counsel Srimati Preeti Patil, male Kundi is requested to take notice for respond number 2. You will get dispensation, huh?
Ouring notice hogli swami, yakko notice.
Notice to respond number 1.
Please.
Learned counsel for appellants is directed to serve copies of the appeal memo along with the annexes on learned counsel for respond number 2.
Please.
Seal number 30, KM Kate.
Here for appellant.
Waiting for respond number 4, members.
Lord, the appellant herein was appointed as a clinical psychologist. On the notification issued by the respondents 2 and 3, a specific qualification was prescribed. Page 42 may kindly be the paper book, my lord. In page 43, the qualification prescribed to the clinical psychologist, my lord, must pass the following qualifications: MSc, MSc in psychology, MA in psychology, MSc in applied psychology, or MSc in holistic psychology, or MSc in psychology counseling. This was the required qualification, my lord. Under these required qualifications, my lord, myself and respondent number 4, we have filed an application. And accordingly, walk-in interview was conducted. In that walk-in interview, my lord, the selection committee has allotted the marks. Page 58, my lord, Manager K. I was allotted 64.53 and the respondent number 4 was allotted as 64.49. Based upon this recommendation of the selection committee, the procedure adopted, my lord, an appointment order was came to be issued in my favor on 12/2/2008, my lord. Annexure U, my lord, page 74. This order of my appointment was came to be challenged in the writ petition by the 4th respondent in 2019. My lord. And when the matter was came up for disposal before the learned single judge, my lord, the 4th respondent contended that she was having gold medal and she was having more merits rather than the appellant herein. That was the only fact was brought to the knowledge of the learned single judge. And looking that, my lord, the learned single judge has quashed the order of selection, my appointment order. Therefore, I am before the honorable court, my lord. First of all, the whatever qualification prescribed by the respondents 2 and 3 authorities, that was not at all taken into account by the learned single judge. And it was not required that the person who applies, he should have gold medalist or the PhD degree certificate. That was not the requirement. When the application was moved, during pendency of that writ petition, my lord, when I was appointed, I have already pursued the PhD degree, my lord. And thereafter I was granted PhD degree. And even my appointment, the promotion has been already declared, my lord. The kind permission of the honorable court, my lord, I want to produce those documents which are not part of the learned single judge, my lord, records.
Please read paragraph number 8.
Please.
Impugned order. records were secured and it was verified.
Please, my lord.
Then this is what is the finding in paragraph number 8.
Yes, finding of the paragraph number 8, my lord, based upon the PhD degree and she was gold medal recipient, my lord. That was not the requirement as
Not
per the.
as on the date of your filing application.
Please, my lord. That was not the requirement. I should have a PhD degree.
Marks ಕೊಡ್ಬೇಕಾಗಿರೋದು ಹಂಗೆ ಅಂತಲ್ಲ.
Allah, that is wrong, my lord. That's what I request the lordship.
Yes.
Kindly turn to Annexure B, my lord. Annexure B, page 42. Firstly, notification was issued on 10/8/2018, calling application for various posts by way of corrigendum, my lord. Annexure B, the relevant page Annexure C nalli, the qualifications which have been prescribed for the post of this clinical psychologist, my lord.
Yes.
So here, my lord, must possess the following qualification. Page 43, my lord.
These are eligibility criteria.
Please, my lord.
Yes.
Yes.
The manner in which marks have to be awarded
Please, my lord.
as what is considered here.
No, that is.
Where do you get this?
Yes. My lord.
Who is appearing for the university?
Your
For the-
medical college, my lord. Ravi Patil appears.
From where do you get this requirement?
But
As what was found by the learned single judge?
but the notification not issued, the first notification dated
10/8/2017. Page 14, my lord. Criteria for drawing up the merit list for medical, ಅಲ್ಲಿ ಬಂದು ಬಿಟ್ಟು for this clinical post, my lord.
page number 14 and
See, it commences from page number 39.
Please.
Method of selection
Selection
criteria.
Yes.
1. Criteria for drawing up the merit list of so and so, so and so.
Please.
Number of publications in national indexed journal, maximum 2 marks. Number of publication in international journals, 2 marks. WHO fellowship, subject university, gold medal, 1 mark. Higher experience, half marks. Presentation of papers, 2 marks.
Yes.
Personality, presentation in the interview, 6 marks. This is the criteria. This is what has been.
That was changed, my lord.
Roman
Four.
6 next date. and
Ah,
next
Roman
page.
4, my lord.
This is specifically, my lord, in respect of clinical psychology.
Yes.
Roman 4.
Sorry,
Roman 4.
yes.
The method of recruitment shall be on the basis of a merit. The merit list shall be prepared by adding 85% of aggregate marks obtained in the qualifying examination and the marks obtained in the interview conducted by the selection committee. The maximum marks in interview shall be 15 and shall be distributed as follows. But this notification.
Higher qualification, PhD, if you have 4 marks.
Now, my lord, this
Gold medal
notification.
in qualifying examination, 1 mark. Experience in BRIMS, maximum 5 marks. This is what has been considered.
This is as per my lord notification dated.
Not that,
Please.
not that the requirement was not PhD.
No.
You are right. Requirement is not PhD.
Please go.
That is the minimum eligible
Please.
qualification.
Yes.
But if you have all this additional qualification,
Yes. Ma'am. Now.
be awarded that much marks as indicated already.
Now, what are the selection committee who have allotted the marks, my lord?
May I add? May I complete my?
Yes.
This notification dated 10/8/2017. My lord, was considered insofar as other posts, my lord, 29 posts. Except, my lord, this post of clinical psychology, which could be found at page number 42.
The post of clinical psychology is excluded from the walk-in interview. Your Lordship, could page number 42. The post of clinical psychology is excluded from walk-in interview for various posts for BRIMS, either to be held on 11/9/2017 at Bangalore. The
Will be
post of
called
clin-
separately.
Yes, it will be called. The reason, my lord, is, my lord, there was no regulations framed as per the bylaw for this post is concerned. Now may request, my lord, page number 22. Sorry, 44, my lord. 44 annexure C. One more notification came to be issued on 18/9/2017. Now method of,
45.
Notification
43,
page
my lord, is the-
42.
43 is the
Ah.
notification
Ah.
dated 18/9/2017.
Ah.
Now, my lord, may take next page, my lord, 44, method of selection. Page number 44, method of selection. The method of selection shall be on the basis of 85% of the qualifying examination marks and 15% interview marks.
Yes.
The merit is assessed on the basis of performance of the applicant and the marks obtained in the interview. ಅಷ್ಟೇ, ಇಲ್ಲಿ categorization ಮಾಡಿಲ್ಲ. ಆ ಮುಂಚೆ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಯಾವ ತರ categorization ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ ಈ ಪೋಸ್ಟ್ ಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಇದು ಒಂದು ಪೋಸ್ಟ್ ಗೆ ಮಾಡಿಲ್ಲ. But earlier notification which was not postponed insofar as this post is concerned, ಆ criteria ನಾನು due to mistake as per the instructions given, I have filed my statement of objection on the last date of disposal. Adralli even I could go through only annexure A, the criteria fixed there. Iga whether this criteria under annexure A shall continue as one of the criteria for annexure C, is the issue which requires.
How can you give a go by?
Now, that is the reason we have filed, we are filing review petition before your lordship for this clarification.
Clarification alla.
Now, the applications which are received in respect of the petitioner and respondent is pursuant to 18/9/2017 notification. Adakagi now, there is a dilemma.
That is why, sir, we are asking you, even if you now try to take that stand,
yes,
the question will be, if there are certain set standards for appointment, for recruitment, merely because a separate notification was issued in respect of clinical psychologists, can you give a go by to the rest of the requirement?
What I am
you cannot argue like that.
No, what I am informed about, this clinical psychology post was never.
Maybe, sir, it may be by a separate notification.
Illa, our regulations, the regulations, conditions which are
Adike
prescribed.
separate regulations baradilla.
E post
There will be general regulations only.
Oh.
That is why in that earlier application, that was the set standard. Now, merely because you issued a separate notification, can you seek a go by to the other requirement, general requirements?
That is what been done.
Can the free hand be given to the interviewers?
Like governing council has taken that call, saying that since the post of clinical psychology was not approved earlier, it is for the first time this post was approved, and there were no corresponding guidelines for the method of recruitment. Though under the annexure A, that was the reason it was
separate regulation.
Governing council proceeding nalli ಇದೆ.
Where is the
that I will place it.
I have filed
adu entire record I had placed before.
ಹಂಗ್ ಮಾಡಕ್ ಬರೋದೇ ಇಲ್ಲ. Be against the university regulations, which are again governed by the what is that? Union Grants Commission, UGC. See, UGC, that is why when it gives grants to the universities, it will say these are the standards that you will have to maintain. If you don't maintain that standard, you will not be eligible for any grants.
This is a government institution, it is an autonomous institution.
Karnataka State Universities Act nodi hanga. A set regulations will have to be prescribed. You cannot give a separate regulation for one particular subject. Angalla madak barodilla.
Now, ಈಗ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, Bangalore Institute of Medical Science, which is a role model for entire state for the first time, which was established as an independent autonomous institution. The regulations there is as per the subsequent notification. And as per bylaw.
ಏನಿದೆ subsequent notification ಅಲ್ಲಿ?
ಅಷ್ಟೇ 15%
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅಷ್ಟೇ, ಅದರಲ್ಲಿ ಯಾವ ತರ ಅಂತ ಹೇಳಿಲ್ಲ.
ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Annexure
The
K.
same regulations which were prescribed in the earlier application would apply. That is why the learned single judge has gone by that one. You can't take such a stand. ಇಲ್ಲ ನಾವು ಅದಕ್ಕೆ separate notification ಮಾಡಿದ್ವಿ, so that is not applicable. ಹಂಗಲ್ಲ ನೀವ್ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ. Be careful before you take such a stand.
Even I have advised same, but the institution wants to have a clarification on this point.
ಹಿಂಗೆಲ್ಲ ಮಾಡಕ್ ಹೋದ್ರೆ then allegations will
difficulties
be leveled against the concerned person.
Difficulties in now.
Why do you want to take that? ಹಂಗ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
Substantial period he has served. Now, I have made one more request to the management out of record, There is one more nursing institute, which has been established now independently, being under the control of Bidar Institute of Medical Science. There is one more post of similar. If something could be done to accommodate this person, respondent also, I am given that proposal also. It requires some time to
he has worked for how many years?
He worked
2018 appointment.
18.
Please, and even probation was also declared. My respectful submission would be, my lord, let the management take decision, my lord, by creating some supernumerary post. Both of them can be helped, my lord, because now almost age bar, now there is possibility of getting another employment. There will be under problem, my lord. So my respectful submission would be, let the management take their appropriate decision. If they had vacancies, my lord, certainly they can accommodate, my lord. Now already I am 40.
You are 40.
Yes, my lord, 40 years, my lord. And since I was serving earlier there, my lord, from 2013, while walking interview, while marks were allotted, my lord, that experience was also counted by the respondents 2 and 3, my lord. I was serving.
ಅದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇರ್ಬೇಕ್ರಿ. ಇಷ್ಟ ಬಂದಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Now, my lord, I am the sufferer.
Commencing from.
Please, my lord, please.
The UPSC.
Please.
Commencing from UPSC.
Yes.
All these recruitment processes, interview alli, that is why.
Yes.
Supreme Court has issued such guidelines.
Now,
the marks that can be awarded in the interview should be so minimum that it should not affect the marks obtained by the candidate in the written examination.
That was not affected here, my lord, because it was.
ಇಲ್ಲಿ ಹಂಗೇನ್ ಆಗಿಲ್ಲ.
Yes, ma'am.
85% to 15% ಅಂತ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
Please, ma'am.
That is all right.
Yes.
Why all this is to curb the tendency of awarding marks as they want in the interview. ಅದಕ್ಕೆ these set patterns are prescribed. Now, for example, in our rules for designation of senior advocate, in terms of the guidelines issued by the Honorable Supreme Court in that judgment, ಅಲ್ಲೇನೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಪಬ್ಲಿಕೇಶನ್ಗೆ ಇಷ್ಟು, ನಿಮ್ಮ ಎನ್ರೋಲ್ಮೆಂಟ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಏಜ್ಗೆ ಇಷ್ಟು ಅಂತ ಅವರೇ ಎಲ್ಲ ಪ್ಯಾಟರ್ನ್ಸ್ ಎಲ್ಲ ಸೆಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ದಟ್ the persons who are sitting in the interview will not have a free hand. ಅವ್ರ ಇಷ್ಟ ಬಂದಂಗ ಮಾರ್ಕ್ಸ್ ಕೊಡಕ್ ಆಗ್ಬಾರ್ದು ಅಂತಾನೆ ಇದನ್ನೆಲ್ಲ ಸೆಟ್ ಮಾಡಿರೋದು.
Only with the due respect, my lord, now the somehow what they made a mistake, my lord, I can't just but to save myself, my lord, only I can request the lordship, if the management is ready to make some alternative arrangements, my lord.
Opinion I have given, my lord, they have not yet accepted, but as per
till then, my
law,
lord, my appointment may be protected, my lord. Otherwise, I will be totally out, my lord. My wife, children, parents, my lord. I am the only son born to my parents. That is also one more difficulty, my lord. Because of that, I seek, my lord, some protection.
Two thousand eighteen.
Yes, ma'am.
The
12 to
repetition
2018, my appointment order was
was filed in the year 2019.
19, my lord. After 1 year, she filed a writ petition.
Because, my lord, one submission. What has happened, my lords, in this case, my lords, we have obtained all the necessary documents through RTI, my lords. Earlier, there is no, any notification, there is no clear, my lord, provisional list is not provided, my lords. Selection list is not provided, my lord, merit list and final list. Nothing has been provided, my lords. And 15 out of 15 marks, my lord, 12.25, 12.5 has been allotted to the appellant, my lords. For the
Only three marks are awarded.
only 3 marks, my lords. That is the reason, my lords.
ಅದೇ ಈ ತರ ಆಗುತ್ತೆ ಅಂತಾನೆ.
Maybe, my lord, because ultimately.
And even PhD is completed by the present.
Now both are PhD, my lord.
PhD, my lord. But gold medalist and highest marks meritorious was the respond number 4.
ಹೌದ್ರಿ ಅದಕ್ಕೆ ಬರೀ 1 marks ರೀ.
One marks.
Only 1 marks ಅಷ್ಟೇ.
Yes, my lord. Then she, however, 85%, my lords, she was more better position than the comparing to the appellant, my lords.
When corrigendum was issued, that was
Yes,
not
my lord.
taken into account.
Page
my lord.
number 56, my lords.
That's why it was.
That is the reason they have made major corrigendum and even last week, my lords, Supreme Court has held that advertisement once made should not be made. Guidelines has been made by Constitution.
Their
bench.
rules
So-
should not be changed.
Yes, my lord.
Once the recruitment process
Yes,
is
my lord.
commenced.
Yes, my lord. That Constitution bench has also made a.
Even under the selection process, my lord, the Honorable Apex Court has also held that the selection committee powers cannot be interfered. That is also there. But here, my lord, I am just seeking protection. Let the
Now
management take
the
whatever
respondent
decision. my
number
lord.
4 is also 42 years old, my lord, and she is still not permanent job, my lord. Still under
You are older than this person.
yes, my lord, 42
Just
years.
1 year, just 1
2
year.
years.
Or 41 or you are 40 as on today.
By this time, you should have come up with that suggestion.
My lord, now, my lord, the decision, the difficulty is, my lord, the governing council is the appointing authority, which is headed by the Secretary of Medical Education. Institution is headed by, my lord, the dean and director. My lord, dean is only a member secretary to the governing council. Every matter, wherever, my lord, such appointments are to be, my lord, considered or modified or relooked into, it is only governing council. My lord, governing council will sit only thrice, once in a 3 months. My lord, every, my lord, these decisions, my lord, now the situation is, my lord, both petitioner and respondent, fairly speaking, my lord, the process adopted is somewhere, my lord, not up to the mark. My lord, only, my lord, I could suggest to the institution, my lord, is to create one more post and, my lord, accommodate both of them. That, my lord, view I have, my lord, given to, my lord, the concerned director now. My lord, however, decision has to be taken by the GC. If some, my lord, direction, my lord, I how far it is, my lord, to safeguard both the interest of both. If some, my lord, direction to consider, my lord, this issue, everything could be resolved.
Only on that ground. That gold medalist anta.
No. Percentage is a percentage.
Percentage ಅಲ್ಲಿ he
No,
has
no,
got
no,
it.
no, my lord.
Academics ನಲ್ಲಿ ಇವ್ರು ಜಾಸ್ತಿ.
Academically, we are higher marks. My
No,
lord.
no.
As per page number, my lords.
A little bit more than you.
No, no, my lord.
Yes.
Interview.
In interview, they are
Chairman.
given 12 and half for
ಅದಲ್ಲ ರೀ. Marks obtained by you in the
that I will go.
academics.
Academics is 10
ಅವ್ರು
10
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ ನಿಮ್ಕಿನ್ನ.
Annexure K, my lord, please.
64 ಇಬ್ಬರದು 64
Yes.
No, 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 my lord.
ಡೆಸಿಮಲ್ಸ್ ಅಲ್ಲಿ ಅವ್ರು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ.
No, my lord. Here,
Four,
in this, my lord,
53 ಇದೆ ಇವ್ರದ್ದು.
72.35 is our marks, my lord.
ಎಲ್ಲಿದೆ?
Annexure K, page number 42, my lords. 42, my lord. Annexure K, my lords. 72.35 is our marks, my lords. Percentage, my lords. Annexure K, my lords.
58
ಅಲ್ಲ ಇಲ್ಲಿ ನಮ್ದು
Page
ನಾಗವಣಿ
ಇಲ್ಲ ನೀವು ಎದನ್ನ ಬಿಟ್ ಅಪ್ಪಿಲ್ಲ page 58
58.
ಹಾ
Annexure K, my lords.
ಕರೆಕ್ಟ್.
Nagavani is the petitioner, my lords.
ಹಾ
Serial number 4, my lords. 72 is the percentage, my lords. Whereas the percentage of the Shivkumar, the appellant,
61.
61, my lord. 72 is our marks, my lords. 72.35 is the aggregate marks, what we obtained.
Column number 9. Column number 9.
Qualification.
Column number 8, 9 is.
9 ದಲ್ಲಿ 85% of the academics if considered, the
Percentage is.
ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಅವ್ರದ್ದು 61.49 ಇವ್ರದ್ದು.
No, that is, my lord.
Shivkumar will be only 52.06.
ಹೌದು.
Para number, column number 8, my lord, 72.35 is ours.
The actual marks is in
Yes.
column number 8.
Yes.
Actual marks is column number 8.
61.49.
85% of
ಅದನ್ನ 85% ಮಾಡ್ಕೊಂಡ್ರೆ ಇಷ್ಟು ಬರುತ್ತೆ.
Yes, ma'am.
ಇವರಿಗೆ
61.49
61.49 ಆಗುತ್ತೆ, ಅವರಿಗೆ 52.6 ಆಗುತ್ತೆ.
They are 10
Almost
marks less,
9 marks minute variation.
ಅದೇ
Probably ಅದಕ್ಕೆ ಆ interview
ಅದನ್ನ
And even my lords.
ಇವರಿಗೆ ಬರೀ 3 ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ 12.5 ಕೊಟ್ಟರು.
One more submission, my lord. Respond number 2 themselves have stated that it is illegal and they have given in the RTI, my lords. What we have, RTI document has been submitted, my lords. That has been submitted, my lords, and that was placed before the honorable learned single judge, my lords. Before the, at that time.
This had come up earlier for preliminary hearing. This is the first time.
Second time, Lord. My lord has already ordered the notices for the respondent, sir. I have served the copies also. Please.
One humble request.
Huh?
Humble request. ನಾನು ಏನ್ ಹೇಳಿದೀನಿ, it is as an officer of the court, not as a my lord. Let it not come as a consent or.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the appellant submits. That the interview for selection to the post of clinical psychologist was held on 16/10/2017 and the final selection list was announced on
Subsequently, my lord, that record.
No such any reports available.
Huh?
They have not publicly not done anything, my lord. And this is also agreed by that only we have filed it, my lord. Only appointment today they have announced the result and they have given appointment letter to immediately.
Those records are.
objections file ಮಾಡಿದ್ರೇನ್ರಿ ನೀವು?
ಮಾಡಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಹೇಳಿದಾರ ಡೀಟೇಲ್ಸ್?
We have filed the
documents which have been submitted by the
Statement of objection ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿ.
ಏನ್ ಡೇಟ್ ಹೇಳಿದೆ ನಾನು? 16/10/2017. ಏನು ಡೀಟೇಲ್ಸ್ ಇಲ್ವಲ್ರಿ? When was the final selection list announced?
Minister. So objection was filed on the last date, my lord. The day
ಆಯ್ತು. When were you appointed?
12/2/2018, my lord, I issued appointment order. Annexure U, my lord. Will repeat.
My lords, one submission, my lords. The, my lord, permitted, I have filed before the learned single judge, my lord. Wherein Brims Institute MD, director himself has stated that their appointment is illegal. And based on that only, the honorable court has passed that order, my lords. That if lordship permits, I would pass this for the, they themselves, the body themselves has given the, in RTA and even furnished to the institute also it has been addressed, my lords. From the respond number 2 to respond number 4, my lord. The appointment, lordship, there is.
ಆಯ್ತು ರೀ.
Yes, ma'am.
We should also think of this person, see.
My lord.
So age 40-41.
Yes, my lord, but our life has been spoiled.
ಹೌದ್ರಿ, that is why we are considering the submission of the learned council also.
Yes, yes, ma'am.
If possible, let them accommodate both of you.
Please, ma'am.
That is why we are recording this.
Yes.
Annexure U, na page number ಏನು?
My lord. Page 74, my lord.
70?
74, my lord. Paper book, my paper.
ಅದು ನಿಮ್ಮ ಲೆಟರ್ ಅದು. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಲ್ರಿ.
Appointment order, my lords,
ಇಲ್ಲಿದೆ.
71.
71, my lord.
71, it's.
It starts at 71. Order at 72, my lord. Annexure T, my lord.
And provisional selection list was announced on 23/11/2017. And the final selection list was approved by the governing council on 1/12/2017. Full stop. Thereafter, appointment order was issued to the appellant herein on 9/12/2018, in terms of annexure T. Full stop. Learned counsel submits that the appellant has been working since February 2018 and till the impugned order was passed by the learned single judge on 23rd of September 2024. Full stop. It is submitted that the writ petition itself
25
filed
2019.
on 25/4/2019.
Please.
After lapse of more than a year after the appointment of the appellant. Full stop. The writ petition should have been dismissed on the ground of delay and laches. Full stop.
No. Writ petition is allowed.
Writ petition.
Allowed ಆಗಿದೆ.
Huh?
ಇದರಲ್ಲಿ.
ಅವ್ರು ಹಾಕಿದಲ್ವ ರಿಪಿಟಿಷನ್
ಹೌದು, ಹೌದು.
ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ ನೀವು
Yes,
ಹೇಳ್ತಾರೆ.
please go.
That is what I am saying.
Please, sorry.
Expert per contra, learned counsel for the contesting respondent number 4 contends that the learned single judge has taken note of the fact that the criteria for awarding marks during the interview was not followed as was provided in the notification.
Annexure B.
Annexure
B. Subsequently, corrigendum was issued. That was Annexure C, my lord, method of selection for this post only.
Annexure E, page
Annexure
number.
B is the corrigendum. Annexure A.
My lord.
At Annexure A dated 10/8/2017. We find that the appellant has served as clinical psychologist for more than 6 years.
This lord, and the services have been also probation is also.
And it appears that the probation of the appellant has also been declared as on
26th December 2022. 26th December 2022.
Full stop. The appellant has also crossed the age of recruitment. Full stop. Therefore, at this juncture, if the impugned order is not stayed, the appellant will be out of job. Full stop. Next para. Consequently, there shall be an interim stay of the impugned order passed by the learned single judge till the next date of hearing. No, the consider we will not record all this. Huh?
My lord, date may be fixed, my lord, because she is running out of age, my lord, now.
ಹೌದ್ರಿ ಗವರ್ನಿಂಗ್ ಕೌನ್ಸಿಲರ್ ಮೀಟ್ ಮಾಡಿ ಅವರು ಡಿಸಿಷನ್ ತಗೋಬೇಕ್ರಿ.
That you want to.
One line, my lord, if it could be, my lord, I can place it before, my lord,
The respondent.
2 and 3.
The governing council of the second respondent, Bidar Institute of Medical Sciences, may also consider appointment of the fifth respondent. Fourth respondent.
He could be accommodated.
In any other vacant post in the institution. Huh?
Yes, please.
Full stop. Release this matter. On 27th of November. Full stop. A copy of this order shall be served on the learned counsel for respond number 2.
Please.
Yes.
Much obliged.
Seal number 31, Prashant B, version 3.
And for the petitioner, my lord.
Yes.
But petitioner was working as Gram Panchayat Secretary, grade 1, my lord. But a complaint was made on 18/2/2006, my lord, alleging that he has demanded illegal gratification. But based on that, my lord, the trial court, my lord, after a detailed trial, my lord, acquitted the petitioner honorably by order dated 27/5/2010, my lord.
2010 now.
Yes, my lord.
Thereafter, my lord, after 2 years, my lord, on 5/1/2012, a departmental inquiry was also initiated after lapse of 6 years, my lord. My lord, the inquiry officer held the charges as proved. And based on that, my lord, a penalty was imposed on 15/3/2016, compulsorily retiring the petitioner, my lord. Against that, he approached the tribunal, my lord. Tribunal granted interim stay and, my lord, by an order dated 25/5/2018, my lord, while setting aside the order of penalty, my lord, remitted the matter to the first respondent to reconsider, my lord, the explanation submitted by him to the second show cause notice, my lord. Lord, on 5/12/2023, my lord, without considering the explanation, my lord, proceeded to impose the very same penalty, my lord. That was challenged before the tribunal, specifically contending that the finding of the inquiring authority are perverse. And, my lord, none of the witnesses, of all the three witnesses, complainant, PW1, PW2, all the three have turned hostile. And, my lord,
where is that previous order?
Previous order at page 100, the lordship will get at page 109, my lord, on Annexure A8. But the relevant para would be page 117, para 8, my lord, 8, 9, and 10, my lord. Lord, on perusal of the judgment of the trial court dated 27/5/2010, in the criminal case, it is seen that PW2 and 3 had turned hostile, and applicant, however, was acquitted in view of lack of corroborative of certain aspects which are essential to establish the charge beyond reasonable doubt in the criminal proceedings. This is the observation of the tribunal, my lord, but I was acquitted honorably, my lord. I will show your lordship about that, my lord. We do not find any merit in the contention of the applicant that the judgment of the trial court can be called as honorable acquittal, and initial disciplinary proceedings was bad on account of delay. I had raised the question of delay, my lord, because the alleged incident had taken place in 2006 and 2012, my lord. After lapse of 6 years, my lord, they had initiated departmental inquiry, that too after acquittal by the trial court. My lord, section 8(2)(d) of the Lokayukta categorically says that if there is any complaint beyond 5 years, cannot be entertained at all. Ignoring that aspect, my lord, the tribunal proceeds on the footing that there is no delay in initiation of inquiry. Now, my lord, in Anantar Kulkarni versus so and so has held that the court that the tribunal should not generally set aside the departmental inquiry and quash the charges on account of delay in initiation of disciplinary proceedings. As such, the prayer is dehashed the limits of judicial review. It was stated that therein that the court must consider all relevant facts, balance and weigh the same, and decide whether in the interest of clean and honest administration, the procedures are allowed to be deserved to be terminated only on account of delay. Considering the chronological background, we are of the view that the disciplinary proceedings cannot be held to be bad on account of delay in the facts and circumstances of the case. But it was my specific case that section 8.2 do not provide for initiation of inquiry if it is beyond 5 years. As regards the plea of the applicant relating to non-consideration of the reply given by the applicant in response to the second show cause notice, it is worthwhile mentioning that the Supreme Court in the case of National Fertilizer versus so-and-so, in contest of disciplinary inquiry, has framed an issue that whether it is necessary for the disciplinary authority to give reasons for agreeing with the EO's report when delinquent officer has submitted a representation challenging the report of the EO. Therein, after considering the various judgments, including one in the case of Managing Director ECIL Hyderabad versus Karnataka P, the Supreme Court has concluded that when disciplinary authority agrees with the finding of the EO, it is not necessary for the disciplinary authority to restate the reasoning. As regards the contention of the applicant that the impugned order does not reflect application of mind, it is seen that the government order before taking the impugned decision specifically states that the reply of the applicant has been examined in detail. It also says that in view of the recommendations of the Uplokayukta, it is decided to impose the penalty of as per Rule 8.6 of the CCA rules. Though de novo examination of all issues is not envisaged at this stage, at least a brief discussion on key aspects raised by the applicant is necessary. Moreover, the disciplinary authority has taken the independent view, has to take an independent view and cannot be solely guided by the recommendations of the Uplokayukta on the matter of penalty. Non-adherence to the aspect has vitiated the impugned order. However, it is open to the government to pass a fresh order after considering the reply of the applicant to the second show cause notice in accordance with law. This is the observation made by the tribunal, my lord. After this, my lord, an impugned order came to be passed at annexure, next page, my lord, 120.
You also did not challenge this order?
Lord, I did not challenge this with the order for the reason that, my lord, the matter was remitted with direction to consider my explanation, reply
but
to
your contention regarding delay.
Yes, ma'am. But that I had taken in my explanation to the second show cause notice. But the tribunal directed the authorities to reconsider the explanation submitted.
Where is that contention of yours?
But my contention is that second show cause notice explanation I have submitted, my lord, is at page 93, my lord. But you'll ask me kindly see page 95, para 3, my lord. I had specifically taken the contention that I have been acquitted honorably in the trial court. Then, my lord, you'll ask me kindly see para 4, my lord. The finding of the inquiring authority without any basis and without any evidence in this, this is evident from. I had also culled out all the relevant, this one, my lord, the perversity in the witnesses examination. Thus, there is no evidence to support the charge. The IO had demanded and accepted the illegal, that the IO had demanded and accepted the illegal gratification. The charge made against me is that I demanded and accepted a bribe of ₹1,500 from the complainant on 28/2/2006. In the absence of any evidence to support the charge, inquiry officer could not have held the charges as proved. The inquiry authority has also come to the conclusion holding the charges as proved on the basis unfair.
Where is your contention regarding delay? You have not said anything.
Not delay is the one ground, my lord, which the application was not considered, my lord, with regard to honorable acquittal, my lord. I had taken a specific contention, my lord. I was acquitted honorably. And, my lord, all the three witnesses who were examined had turned hostile in the inquiry. And you'll ask me kindly see the finding of the disciplinary authority subsequent to the order of the tribunal, my lord, at page page 100 and 20, my lord. My lord, I'll only draw your lordship to attention to page 130, my lord. Last paragraph, my lord. My lord, last paragraph, my lord. ಮಾನ್ಯ ಕರ್ನಾಟಕ ಆಡಳಿತ ಮಂಡಳಿ ನೀಡಿರುವ ತೀರ್ಪಿನಂತೆ ಕಡತದಲ್ಲಿನ ದಾಖಲೆಗಳು ಮತ್ತು ಆಪಾದಿತ ನೌಕರರು ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ಗೆ ಸಲ್ಲಿಸಿದ ಲಿಖಿತ ಉತ್ತರವನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಆಪಾದಿತ ನೌಕರು ಶ್ರೀ ರಮೇಶ್ ತುಮಕುಂಟ ಇವರು ಮುಖ್ಯ ವಾದವೇನೆಂದರೆ ವಿಚಾರಣಾಧಿಕಾರಿ ತಮ್ಮ ವರದಿಯಲ್ಲಿ ನೀಡಿದ ಫೈಂಡಿಂಗ್ ಯಾವುದೇ ಸಾಕ್ಷಿ ಪುರಾವೆಗಳು ನೀಡದಂತೆ ವಿಚಾರಣೆ ವರದಿಯಾಗಿರುವುದರಿಂದ ದ ಫೈಂಡಿಂಗ್ ಆಫ್ ದ ಎಂಕ್ವೈರಿ ಆಫೀಸರ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ನೋ ಎವಿಡೆನ್ಸ್. ಸದರಿ ವರದಿಯನ್ನು ಒಪ್ಪಿ ನನ್ನ ಮೇಲೆ ದಂಡನೆ ವಿಧಿಸುವ ಕಾನೂನು ವಿರುದ್ಧವಾಗಿರುತ್ತದೆ ಎಂದು ಹೇಳಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ಲಿಖಿತ ಉತ್ತರವನ್ನು ಒಪ್ಪಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ, ಏಕೆಂದರೆ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ವಿಚಾರಣಾ ಕಾಲದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರ ನರಸಪ್ಪ PW1, ಮಹದೇವಪ್ಪ PW2, ಮೋಹನ್ ಸಾದಿಕ್ PW3 ರವರು ವಿಚಾರಣಾ ಕಾಲದಲ್ಲಿ ನೀಡಿರುವ ಹೇಳಿಕೆಗಳನ್ನು ಗಮನಿಸಿದಾಗ ಹಾಗೂ ಎಕ್ಸಿಬಿಟ್ P1 ಹಾಗೂ P6 ರಂತೆ ಗುರುತಿಸಿದ ದಾಖಲೆಗಳನ್ನು ನೋಡಿದಾಗ ಆರೋಪಿತರ ನೌಕರರಾದ ರಮೇಶ್ ತುಮಕುಂಟ ಅವರು 1500 ಲಂಚ ಪಡೆದಿರುವುದು ದೃಢಪಡುತ್ತದೆ. ಅದರಂತೆ ಕೈಂಡ್ಲಿ ನೋಟ್ ಮಾಡಾಡ, ಅದರಂತೆ ಆರೋಪಿತ ನೌಕರರು ವಿಚಾರಣಾ ಕಾಲದಲ್ಲಿ ಮೇಲಿನ ಅಂಶಗಳ ಮೇಲೆ ಯಾವುದೇ ಪಾಟಿ ಸವಾಲು ಮಾಡದೆ ಇರುವುದರಿಂದ ಆಪಾದಿತ ನೌಕರರು 1500 ಹಣ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದು ಪಡೆದುಕೊಂಡದ್ದು ನಿಜವಾಗಿರುತ್ತದೆ. Kindly come to the deposition of PW 1 to 3, my lord, page 198, my lord. Lord, this is a deposition of PW1, my lord, complainant. It starts at page 194. My lord, he has turned hostile, my lord. Your lordship will get at page 195, having turned hostile, my lord, the disciplinary authority presenting officer has cross-examined him. Now, my lord, at page 198, my lord, I have cross-examined. Your lordship may kindly see, my lord, the second line. ನಾನು ಸಹ ಆಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಯಾವುದೇ ದೂರನ್ನು ಸಲ್ಲಿಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. This is the complainant's version. ತಾಲೂಕು ಪಂಚಾಯಿತಿಗಳಿಂದ ಮಂಜೂರಾಗಿದ್ದ ಮನೆ ಕಟ್ಟಿಸಿಕೊಳ್ಳಲು ನನ್ನ ಹೆಂಡತಿಗೆ 7500ಗಳ ಚೆಕ್ ನೀಡಲಾಗಿತ್ತು ಎಂದರೆ ನಿಜವಿರಬಹುದು. ಆದರೆ ಎಷ್ಟು ಮೊತ್ತದ ಚೆಕ್ ಎಂದು ಸರಿಯಾಗಿ ನೆನಪಿಲ್ಲ. ನನ್ನ ಹೆಸರಿಗೆ ಯಾವುದೇ ಚೆಕ್ ಕೊಟ್ಟಿಲ್ಲ. ಮನೆ ಕಟ್ಟಿಸಲು ಉದ್ದೇಶಿಸಿದ ನಿವೇಶನ ಸಹ ಹೆಂಡತಿಗೆ ಹೆಸರಿಲ್ಲದಿತ್ತು. ನನ್ನ ಹೆಬ್ಬಟ್ಟಿನ ಸಹಿ ಪಡೆದು ದಾಖಲೆಗಳನ್ನು ನನಗೆ ಓದಿ ಹೇಳಲಿಲ್ಲ. ನಾನು ಆಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರಿಗೆ ನಮ್ಮ ಪಂಚಾಯಿತಿ ಅಧ್ಯಕ್ಷರ ನಿರ್ದೇಶನದಂತೆ ಹಣ ಕೊಟ್ಟೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆದರೆ ಆ ಕಾಲಕ್ಕೆ ಅಧ್ಯಕ್ಷರನ್ನೊಳಗೊಂಡಂತೆ 4 ಜನರು ಹಾಜರಿದ್ದು ಹಣ ಕೊಡು ಎಂದು ಹೇಳಲಾಗಿ ಹಣವನ್ನು ಕೊಟ್ಟೆ. ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಹೆಸರಿಗೆ ಮಂಜೂರಾಗಿದ್ದ ಮನೆಯನ್ನು ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಕಟ್ಟಿಸಿದ್ದೇವೆ. ಆ ಬಗ್ಗೆ ನಾನು ಯಾವುದೇ ಲಂಚ ಕೊಟ್ಟಿಲ್ಲ. This is the complainant's version, my lord, during the cross-examination. Now, my lord, DW2 also has been cross-examined, who had turned hostile. Page 201 is the cross-examination. And PW3 also, my lord, I have cross-examined him. And the disciplinary authority comes to conclusion that I have not cross-examined them with regard to the alleged demand and acceptance. And he holds that on the basis of the perverse findings of the inquiry officer, my lord, I have been once again placed under, I have been imposed with the penalty of compulsory retirement. And acquittal is honorable, my lord. Your lordship may kindly come to the trial court order, my lord, at page 61, my lord, para 15. It is honorable acquittal, my lord. Your lordship may kindly come to para 15, my lord.
Page number
61, my lord. I'll read para 15, my lord. Yes. After 11 lines, my lord, the prosecution has failed to produce evidence to prove the fact that the accused demanded money from the complainant and the complainant paid the money to the accused as illegal gratification. The evidence of PW1, 3 and 6 relied by the prosecution clearly established the fact that the accused was not at all demanded an amount of ₹1,500 as illegal gratification to show official favor. After considering the entire evidence on record, I have no hesitation to hold that the prosecution has not succeeded in providing beyond all reasonable doubt the charge leveled against the accused. Though the prosecution has produced some evidence as regards the alleged allegations and the charges, such evidence, in my considered view, is not at all sufficient to hold the accused guilty positively and conclusively, and a reasonable doubt arises in the mind of the court about the credibility of acceptability of the case of the prosecution as spoken by PW2 and PW7, with slender support from the witnesses like PW2 and PW7. Thus, on considering all the aspects of the matter and due appreciation of the entire evidence and attending the circumstances, I am of the considered view that the prosecution has failed to bring home the guilt of the accused. Accordingly, I answer the point under consideration in the negative. My lord, on the basis of this, my lord, the recent judgment of Honorable Supreme Court, my lord, which I have produced, my lord, in the Ramlal's case, my lord, it was decided in 2024, my lord. My lord, your lordship may kindly come to page 169, my lord. This is the recent judgment of the Honorable Coordinate Bench of Bangalore, my lord. Page 169, my lord.
Supreme Court judgment.
Supreme Court, no, page 169 is the division bench, my lord, referring to Supreme Court judgment, my lord.
Huh?
Page 169, your lordship.
169 of?
The pleadings, my lord.
Pleadings.
My lord, your lordship may kindly come to, my lord, page 177, my lord.
Supreme Court judgment will torsi.
Yes, my lord. That is at, my lord, para 30, my lord. We are additionally satisfied that in the teeth of the findings of the appellate judge, the disciplinary proceedings and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, and circumstances were all same. This is a case where, in exercise of our discretion, we quashed the order of the disciplinary authority and the appellate authority, as allowing them to stand will be unjust, unfair, and oppressive. This case is very similar to the situation that arose in GM Tank. That is also judgment of Supreme Court, my lord. Not placing reliance on this judgment, my lord. Your lordship may kindly again, para 28, my lord, the expression benefit of doubt is being expressed. Para 28, my lord. The expression like benefit of doubt and honorable acquittal used in the judgments are not to be understood as a magic incantations. A court of law will not be carried away by mere use of such terminology. In the present case, the appellate judge has recorded Exhibit P3, the original mark sheet carrier, the date of birth as 21/4/72, and the same has also been proved by the witnesses examined in behalf of the prosecution. The conclusion that the acquittal in the criminal proceedings was after full consideration of the prosecution evidence, and that the prosecution miserably failed to prove the charge, can only be arrived at after reading of the judgment in its entirety. The court in the judicial review is obliged to examine the substance of the judgment and not to go by the form and the expression used. Lord, in the both the criminal proceedings as well as in the departmental inquiry, my lord, the witnesses are one and the same, and the documents relied are one and the same. In fact, my lord, in the departmental inquiry, my lord, all the three PW1, complainant, shadow, and the Pancha witnesses have turned hostile. And my lord, the investigation officer also had expired. In his place, my lord, a constable who had accompanied him was examined. Based on the constable's deposition, my lord, the finding of the inquiring authority is that the charges are held as proved, my lord. And the disciplinary authority, without noticing that I have cross-examined all the witnesses in detail, comes to conclusion that I have not examined them and therefore accept the deposition of the persons who have, my lord, turned hostile.
All right. Learned AG takes notice for respondent number 1. Lokayukta yaar prakara?
Mallapur. Subhash Mallapur.
Learned Counsel Sri Subhash Mallapur is requested to take notice for respondent number 2.
2 and 4.
And 4. Iವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರ ಅಲ್ಲಿ? Learned Counsel Sri DP Ambekar is requested to take notice for respondent number 3.
Before tribunal, Busre was there, man.
Huh?
Before tribunal, Busre was appeared.
ಅವ್ರನ್ನೇ ಹಾಕಿ. Usare. Learned Counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate as well as learned counsel for the other respondents. Full stop. Next para. Learned counsel for the petitioner submits that despite the fact that the criminal proceedings initiated against the petitioner were dismissed and the petitioner was acquitted honorably. Where is that?
Right, page 61, madam.
Page 61.
Yes. Acquittal of the petitioner in trial court, madam.
Next, A1.
At the hands of the principal sessions judge Kalaburagi in special case number 87 of 2007 by order dated 27 by judgment dated 27/5/2010. Come on, nevertheless. Disciplinary proceedings were initiated against the petitioner for an incident that had occurred in the year 2006. Full stop. Disciplinary proceedings were initiated in the year 2012. Contrary to the
Section 82D of the Lokaयुक्त Act.
Lokayukta Act kegadena.
How investigation inquiry is held by the Lokaयुक्त only.
That is after entrustment.
Yes, after entrustment. Lord, Lokaयुक्त sends a report under section 12(3) to the government, my lord, seeking entrustment. Lord,
That is the basis. That is the basis, huh?
Yes, no. Initiation of charge, initiation of inquiry is the issue of charge memo is on 5/1/2012, my lord.
Adikke.
Yes.
For that itself, there is a limitation prescribed, isn't
Yes,
it?
yes, yes.
Which is that provision?
Section 82D, my lord, of Lokaयुक्त Act.
Lokaयुक्त Act already. Namma idradu CC.
CCA rules, there is no such. CCA rules, there is no such limitation. Lord, the investigation itself was initiation. My lord, the complaint was given on 18/2/2006, my lord.
214 ಯಾವುದು ಇದೆಯಲ್ರಿ? How can you say that?
No. 214 is with regard to retirement, my lord.
See, there is a provision even under the
CCA rules, my lord.
CCA rules.
No.
That inquiry or disciplinary proceedings cannot be initiated against an incident that has happened beyond so many years. Ante yavado on provision ilva?
That is only in respect of retired employee, my lord. Rule 214 of KCSR, my lord. It says
only in respect of retired employees.
Yes, my lord. That is only in respect of retired.
214
8/2D, my lord.
B.
D, my lord.
5 years. Provisions contained in section 8(2)(D). Which prohibits action being taken in respect of an incident alleged to have been committed 5 years prior to the complaint. Full stop. Moreover, on a previous occasion, the Karnataka State Administrative Tribunal had remanded the matter back to the disciplinary authority. with a direction to reconsider the explanation offered by the petitioner herein to the second show cause notice. Stop. Learned counsel submits that both the disciplinary authority as well as the tribunal have failed to notice that the acquittal of the petitioner in the criminal proceedings was clearly for want of evidence that could prove the guilt against the petitioner. Full stop. The charges considered under in the criminal proceedings were the same as the one considered in the disciplinary proceedings. Full stop. In this regard, learned counsel places reliance on a recent decision of the apex court in the case of Ramlal versus State of Rajasthan and others, bracket early 2024, close 1 SCC 175, wherein it was held that the conclusion that the acquittal in the criminal proceedings was after full consideration of the prosecution evidence, and that the prosecution miserably failed to prove the charge can only be arrived at after a reading of the judgment in its entirety. Full stop. That being the position, both the disciplinary authority as well as the tribunal have erred in coming to a conclusion that the acquittal of the petitioner in the criminal proceedings was not honorable, and on the other hand, it is a benefit of doubt. Full stop. The tribunal has also erred in coming to a conclusion
Page 32, last
that
three lines.
the petitioner has not elicited any evidence in the cross-examination of the official witnesses which should lead to an inference that the allegation made against the petitioner was not proved. Full stop. Attention of this court is drawn to the cross-examination of
PW 1 to 3, madam.
PWs 1
1
to 3.
Yes, ma'am.
And more particularly, the cross-examination of the complainant.
Yes, my lord. PW 118,
Was
page 1.
categorically admitted that the petitioner did not seek any illegal gratification from the complainant. Full stop. Next para. Matter requires consideration. Full stop. Consequently, there shall be an interim order of stay.
Annexure A9, my lord.
Huh?
He was
Annexure-
benefited the, he is benefited the interim order before tribunal or not, is not stated in there.
But
ಇನ್ನೊಂದು paragraph sir. It is also not, it is also submitted that the petitioner had the benefit of.
Is benefited or not, I don't know.
Lord,
ಇದೆ, ಹೇಳಿದ್ರಲ್ಲ.
my lord, what has happened is, my lord, the first order, that is, my lord, 2016 order, my lord, I had the benefit of interim order, my lord, when it was matter was remitted on 25/5/2018, my lord, I was in the service. Thereafter, my lord, on 5/12/2023, my lord, when they passed a fresh order, my lord, I was not having any benefit of interim order, my lord.
That's why.
ಅದು ಯಾವ್ದು commencing from what date to what date you had that benefit?
From 25/5/2018 to 5/12/2023.
Of interim protection at the hands of the tribunal between 25/5/2018 to 5/12/2023. Full stop. Matter requires consideration. Full stop. Consequently, there should be an interim order of stay.
Lord, stay of annexure A9, my lord, I have wrongly mentioned the annexure, my lord, page 131 is the order, my lord. Am I permitted to carry out the typography?
Where is your application for stay?
Lord, that is along with the interim prayer.
Huh? ಅಲ್ಲ ಇಲ್ಲಿ separate ಆಗಿ stay ಕೇಳಲ್ವಾ ನೀವು?
ಇಲ್ಲ, writ ಅಲ್ಲಿ interim prayer along with the petition only.
Interim prayer.
Petition. These are writ petitions.
But I have wrongly mentioned annexure A7, my lord, it is A9, my lord, which is subsequently passed. Page 131 is the order, my lord.
Of the operation of the impugned order dated 15/3/2016.
No, my lord, it is 5/12/2023, my lord, annexure A9, my lord. Page 131.
5/12/2023.
May I request to lordship to have it next week, my lord, final disposal itself. My lord, is not
Your lordship may
benefited.
grant an interim order, my lord. Your lordship have heard at length, my lord. Let him file the detailed objections for that.
Yes.
Page 131 is the order, my lord.
Five 5/12/2023. At annexure
A9, my lord.
A9. Till the next date of hearing. Full stop. Next para. The learned counsel for the petitioner has pointed out that there has been a typographical error in the interim prayer. Full stop.
I may permit
was
to
intended.
carry out the amendment, my lord, today
What was
itself.
intended to be stayed was annexure A9.
Yes, ma'am.
A9 dated
5/12/2023, ma'am.
5/12/2023 and not the annexure A7. Full stop. Next para. The learned counsel for the petitioner is permitted to carry out the correction in the interim prayer accordingly.
Please.
Yes.
Seal number 32, Mahesh Patil.
My lord, here, my lord, punishment has been imposed, my lord, against me. Punishment, my lord, of withholding 50% of my pension, my lord, has been imposed on me, my lord. My lord, without there being, my lord, any, my lord, first of all, my lord, it's a board, my lord. It's a Khadi employment board, Khadi board.
Retired technical supervisor.
Yes, my lord. And my lord, at that point of time, my lord, the CCA rules were not adapted at all, my lord. Despite that, my lord, they proceeded to exercise, my lord, invoke CCA rules and Lokaikta Act, my lord, and they were, my lord, proceeded to, my lord, impose
There is
punishment.
no interim prayer.
There's no interim prayer.
Learned government advocate takes notice for respondent number 1. Learned counsel Shri Subhash Malapur is requested to take notice for respondent number 3. Issue notice to respondent number 2. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate as well as learned counsel for respondent number 3.
Admission matters, seal number 33, SS Alalli.
In this case, Lord, in this case, in the last hearing, my Lord, it was referred to my Lord, mediation, and they were direct to appear on 28/10. My Lord, both parties did not appear.
Learned counsel.
And my Lord, my parties are not well. So that last week, one date once again
that the parties were not able to appear for the mediation center on 28/10/2024.
Yes.
Due to
ill health.
Ill health. Full stop. Next para. The parties are directed to appear before the mediation center on
first week na one date.
ನೀವು ಹೇಳಿ ಡೇಟು.
Date ಯಾವ್ದಾದ್ರು
You can choose.
So third, my Lord.
3rd of December.
ಅಲ್ಲ ಅವ್ರು ಧಾರವಾಡದಿಂದ ಬರ್ಬೇಕು, ಅವ್ರ ಮಗಳು ಹುಷಾರಿಲ್ಲ, ಇವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ತಕ್ಷಣ ಮಗಳಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಯಾವ ಇಂಟಿಮಿಟೇಟ್.
3rd of December. Yes. 2024 at
1:30.
At 1:30. At 2:30 PM.
Please.
At 2:30 PM. Release this matter on 9th of December. Please.
Seal number 34.
These
additional government
appeals, my Lord, last
This matter, my
occasion,
Lord,
Lordship direct them to furnish the, what is the
4
decision of
cases,
the
my Lord,
committee
4,
on-
one ನಿಮಿಷ.
One
Lord,
minute.
Lord, 4, my Lord,
So
LAC
that
cases.
Lordship kindly see order dated 3/9.
Madam, one ನಿಮಿಷ, let me to make the submission, madam, this why you are making hurry.
Again order ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ನೋಡಿ ಇರ್ರಿ.
ಆರ್ಡರ್ಲೆ ಅವು ಇದಾಗ ಇಲ್ಲಿ ಹೇಳೋಕೆ ಮುಂದೆ ಸ್ಟಾರ್ಟ್
We have
ಮಾಡಿಬಿಡ್ತಾರೆ.
passed some orders. Let us
Yes,
read
my
it.
Lord, and 201002 of 22 then. By going to the order dated 3/9/2024, subsequently Lordship has passed the order.
That they have satisfied the
Yes.
Yes, ma'am.
award in many other cases.
Yes,
But
ma'am.
they have preferred appeals only in
Only
some cases.
yes. Common award, same notification, same village. The satisfied some of the appeals reference.
That's why, my Lord, I wanted to try to make the submission, my Lord, my learned friend is not allowed. Kindly see, my Lord, 34.1, it is of old notification. It is not the same notification. For that is the reason, my Lord, let her prepare the, my Lord, own same notification. It is true that, my Lord, 4 LAC cases, we not prepare the appeal and accepted that and paid that amount. Even SLO also filed the affidavit before Lordship, my Lord, on 7th, my Lord, stating that, my Lord, as on today, we not received the government order for preparing the appeal in those cases also. That is, we filed, my Lord. Confusion here, my Lord, all the cases is mixed up with here. Same notification, same village, let them make the separate list, my Lord. Post those matters, my Lord, separately and dispose of this one. Here, my Lord, for example, my 34.1 for a moment. This 200256 of 2022, it is not the same notification.
May I make my sub, a common award has been furnished before this court, my Lord, along with my memo. We have passed, the LA have passed the common award in all those. I produced the memo along with the award.
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
There are two.
ಅಲ್ಲ ಫಾರ್ ಮೂವ್ಮೆಂಟ್ ಮಲಾಡ್ 34.1 ತಾವು ನೋಡಿಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. 34.1
2022. I filed memo along with the award passed by the LAO.
ಯಾ ಅಲ್ಲಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
Sorry.
ಕಾಸ್ ಲಿಸ್ಟ್ ಇದೆಯಾ?
34.1 ನೋಟಿಫಿಕೇಶನ್ ನೋಡಿಬಿಡಿ ಸ್ವಾಮಿ. ಬೇರೆ
201002.
Yes, my lords.
Huh?
Yes, my lords. I filed this the chart also.
ಯಾವ್ದು ನಂಬರ್ ಇಲ್ಲ ಇದ್ರ ಮೇಲೆ. ನಂಬರ್ ಇಲ್ವಲ್ರಿ ಇದ್ರ ಮೇಲೆ.
Sorry, madam. In my crop MFA 200638, my lord. 200638 of 22, cross appeal 200041 of 23. Two 638, LAC filed by the government, my lord. My cross appeal is 200041. Award passed by the LAO.
ನೋಡ್ರಿ MFA 201002 of 2022 ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್
ಪ್ಲೀಸ್ ನೋಡಿ.
ಅದ್ರಲ್ಲಿ ಒಂದು ಮೆಮೊ ಹಾಕಿದಾರೆ ನೋಡಿ.
ಅದೇ 252 ಅದೇ ಅದಕ್ಕೆ
3/9/2024 ಗೆ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದರಲ್ಲಿ ಮಿಕ್ಸ್ ಅಪ್ ಆಗಿದೆ ಅಂತ ಇದರಲ್ಲಿ. ದಟ್ ಇಸ್ ಫಾರ್ ದ ರೀಸನ್ 34.1 ಏನಿದೆ ಅವ್ನು ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕು.
ಬೇರೆ ನಮ್ ಬಂದು ಅದ್ರ ಪರವಾಗಿಲ್ಲ. What do you say about this one?
We are admitting that, my lord, same notification. That is in other 4 cases, my lord, we satisfied. But those cases, my lord, as on today, my lord, we have not received the government order for preparing the appeal.
That is why the learned counsel is saying, how can you do this?
That's why, my lord, excluding these cases,
ಮಾಡಾಯ್ತಲ್ಲ, ಇವಾಗೇನು ಅಪೀಲ್ ಆಗ್ತೀರಾ?
ಹಾಕಿದ್ದಾರೆ, but there is orally direction as to file the appeal ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. That's why, my lord, we cannot file it. That's why you are.
After having satisfied the claim amount.
Yes, my lord.
Where is the question of you preferring an appeal now?
Yes, my lord. But only these cases, my lord, you will also post this matter, my lord, tomorrow or day after tomorrow, excluding the other cases. But you should not be confused, my lord.
Forget about some other cases which are not actually to be connected.
Yes, my lord.
We will not pass any orders on those matters. But what is your submission regarding the allegation made by the learned counsel now?
But that is, my lord, we are admitting that one, my lord, same notification.
Then
that is true, my lord, that even we agreed in the update of the SL.
Permitted to satisfy the claim amount in respect of some appeals and prefer appeals in some of them.
Yes, that is affidavit of the SLO, my lord, filed, my lord, you will also find this. SLO affidavit, my lord. I filed, my lord, before lord, cross objection. Copy there.
That is why we have specifically stated in our previous order.
Yes. That's why, my lord, he also filed the, my lord, affidavit before lordship, my lord, stating that for that LAC cases, my lord, 1, 2 and 5 something, my lord, 4 cases, no appeal is filed.
No appeal is filed, all right. You have also satisfied the claim
Satisfied,
amount.
that is also, my lord, stated in that. As on today, my lord, government order is not received to preparing the appeal
Where
against
is the
that.
question of you receiving government order now?
That's why, my lord, there is not.
What does it show?
But there is only oral direction, my lord.
You
that
had
is-
no difficulty in satisfying the claim amount where that award amount was enhanced. But you have preferred appeals only in a few of these matters.
That's true, my lord.
That is why the learned counsel made a submission last time. If you are prepared to withdraw the appeals, they will also withdraw the appeal.
But we cannot withdraw that, my lord. We will also pass the order, my lord. Those cross objection can be, my lord, withdrawn that one, my lord. Because unless GO order, my lord, I cannot, my lord, withdraw this appeals, my lord. I am making the submission, my lord, that is even SLO also filed the affidavit.
If the
before us.
appeals are
Because I don't want to take risk, my lord, for that.
dismissed, I will.
This is a financial burden, my lord, for that is the reason SLO also filed the affidavit before lordship. On the basis of that affidavit of the SLO, my lord, you will also dispose of these cases. File ಮಾಡಿ cross ನಲ್ಲಿ ಇವ್ರ cross ಅಲ್ಲಿ
ಅದಕ್ಕೆ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಹೇಳಿದ್ವಿ.
34.14 ದಲ್ಲಿ ಹಾಕ್ಯಾರ 13.14 ಅದರಲ್ಲಿದೆ ನೋಡಿ ಇಲ್ಲಿ ಆಯ್ತು ಫೈಲ್ ಮಾಡಿ ನಿಮ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರೆ
ನಂಬರ್ ಏನು
4.14
20031
ಅದೇ ಸಿಡಿ.
ಬರ್ಕೊಳ್ಳಿ. Despite our specific directions issued on 24/10/2024, recording the submission of the learned counsel for the appellants, that the state has chosen to file appeals only in a few matters arising from the same notification, while satisfying the claim amount along with the enhanced compensation in respect of a few others, and requiring the learned government advocate to secure instructions in this regard, learned government advocate only points out to the further affidavit filed by the special land acquisition officer. Stop. Next para. In the said affidavit, the special land acquisition officer has admitted to the fact that the department has deposited the entire award amount along with consequential benefits in LAC number 1 of 2019, 2 of 2019, 14 of 2019, and 15 of 2019. Full stop. On the other hand, it is also stated that government orders were received for filing appeals in some of the matters, and therefore appeals have been filed. Full stop. Next para. In our considered opinion, the principal secretary, ಯಾರು ಬರ್ತಾರೆ ಇದು? Principal secretary, ಯಾವ department?
This is a revenue.
Revenue.
Irrigation department. This is my project, it's the irrigation, my lord.
Award satisfied ಮಾಡೋದು ಯಾರು?
Revenue.
Revenue na illa.
Irrigation.
Yes, ma'am.
So it will be irrigation department.
Oh, irrigation.
Irrigation department or minor irrigation department?
Minor irrigation. Minor. I'll clarify it and give the.
Irrigation department is required to take note of these discrepancies. Full stop. If the claim has been satisfied in respect of many other claimants, then the question of the state preferring appeals in few other matters arising out of the same notification and in respect of the same villages, comma, would not arise. Full stop. Next para. We expect the concerned authority to give necessary instructions to withdraw the government orders for preferring appeal so that the same can be withdrawn. Full stop. This will also pave way to the claimants who have preferred appeals to withdraw the appeals filed by them. Stop. Next para. Copy of this order shall be served on the learned government advocate for compliance. Full stop. Release this matter on 26th of November.
Please. Those cases is not in the chart, my lord, that can be deleted. D-link ಮಾಡಿದ್ರೆ ಒಳ್ಳೆದು sir. Which chart is given, my lord, only those cases is applying this. Other cases is maybe D-link from these cases.
ಆಯ್ತು ಬಿಡ್ರಿ ಅದನ್ನ ಮಾಡೋಣ ಸೆಪರೇಟ್ ಆಗಿ.
Confuse
Whichever
ಆಗ್ತದೆ.
pertains to these acquisition proceedings, same notification, we will all de-link them and we will dispose of. The rest of them will remain.
Please, please.
ಅವ್ರದ್ದೇನ್ರಿ ಅವ್ರು ಕೊಟ್ಟಿದ್ದ
ನಮ್ದೇನು? Affidavit.
ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿರೋದು?
This is the cross.
ಅದಲ್ಲಿ ಫರ್ದರ್ ಅಫಿಡವಿಟ್ ಫೈಲ್ಡ್ ಇನ್ MFA ಯಾವ್ದ್ರಲ್ಲಿ?
200638, my lord. 200638 of 2022, my lord. In cross.
CL number 35. Additional government advocate.
Connected matter, my lord, he has to comply the office objection, my lord.
ಹಾಕಿದಾರ್ರಿ ಅವರು ಮುಂಚೆನೆ ಹಾಕಿದ್ದಾರೆ.
I'm appearing for the cross object, your lordship. 2 weeks time may be granted, your lordship. I'll do the needful. 2 weeks time may be granted, your lordship. I'll do the needful.
Connected matter, he has to comply the office objection.
2 weeks are granted at the request of learned counsel for the cross objector to comply with the office objection.
Please, lordship. Obliged.
CL number 36, PS Mali Patil.
Lord, I appear for the appellant in this matter, my lord. The matter is, my lord, covered by decision of the division bench of this honorable court. But if it is called tomorrow, my lord, I will argue, and today there is no time, your lordship, that's why.
ಏನ್ matter?
My lord, it is a, my lord, case of compulsory retirement, my lord. The Lokayukta, my lord, after submitting the report, they made a, my lord, suggestion, my lord, an order to be passed for compulsory retirement, which is not permissible, my lord, as per the judgment of this honorable court. I have produced the copy of the order, my lord, passed by the court, my lord, along with my citation is filed in the papers. Lordship, may kindly the first paper itself, my lord, first judgment.
Maresh M.
Judgment, my lord, first judgment, your lordship, page number, last para of the order, kindly, my lord. Para 22 of the judgment. Report of the recommendation made by the to impose a penalty is bad in law and not sustainable. Based on the such legal position, if the learned single judge has come to the conclusion that the recommendation of the Upalokayukta is impose a penalty on the first respondent is bad in law, in this case, the disciplinary authority imposes the punishment on the respondent solely on the reply given not upon the recommendation of the Upalokayukta. Not the recommendation of the Upalokayukta at page number, your lordship gets it, my lord, page number for 94. 94 page, my lord, is the recommendation made by the Upalokayukta. Having regard to the nature of the charge proved against the DGO and the date of retirement of so and so, it is hereby recommended to impose the penalty of compulsory retirement from the service on DGO 1. The financial loss caused to the said number so and so with the interest at so and so annual from so and so is to be realized shall be recovered from the pension payable by the GO. Lord, the impugned order, Lord, at page number 106. 107 ನಲ್ಲಿ, my lord, they refer to the recommendation, my lord, at 105. Page 105. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ ಸೋನ್ಸರನ್ವಯ ಈ ಪ್ರಕರಣದ ಆರೋಪಿಗಳಾದ ಹಿಂದಿ ಸೋನ್ಸ್ ಮುಖ್ಯಾಧಿಕಾರಿ ಸೋನ್ಸು ಇಲಾಖೆ ವರದಿ ಮತ್ತು ಲೋಕಾಯುಕ್ತರ ಶಿಫಾರಸ್ಸಿನೊಂದಿಗೆ ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸು ಸಂಬಳಿಸು ನೀಡಲಾಗಿತ್ತು. ಅದೇ ನೋಡಿ, they have passed a order of compulsory retirement. But the charge, Lord, is that but there was a proposal for construction of a kitchen room, Lord, in a government school, which was, Lord, when they started construction, Lord, up to the roof level, Lord, there was an objection by the, Lord, the public as well as by the headmaster. At that stage, Lord, it was stopped.
Who is the contesting respondent?
Lord, we passed the order, my lord.
Huh?
We state is the passed the disciplinary authority order, my lord. This is the punishment, compulsory retirement. But recommendation made by the Lokayat, my lord, even recovery of that amount of rupees 54,504 of 8% interest. So that was not considered. Only, my lord, he was penalties imposed to retire from the compulsory retirement.
Right.
Which judgment are you talking of, sir?
Man, first judgment citation ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ ಒಂದು separate ಆಗಿ ಒಂದು bunch of papers given.
Memo of citation.
ಇದೆ ಇದು ಕೆಳಗಡೆ ಇದೆ. First judgment may kindly be seen, my lord. This is Justice, my lord, Manjunath and Rajaratna Bhajantri ಅವರು. ಅದರ last portion may kindly be seen, my lord.
Manjunath Bhajantri ಅವರು ಇದೆ.
Para number 12.
ಅದೈತೆ ಇದೆ ನೋಡಿದ್ದೀನಿ ಅದನ್ನ.
ನೋಡಿದ್ದೀರಾ? There are many
Not,
other
as rightly pointed out, ಅದರ last 12, para number 12 is relevant.
Have you gone through this judgment?
Yes, sir, I gone through that, my lord. My submission is, my lord, recommendation is two grounds, my lord. One is compulsory retirement and recover that amount.
You cannot.
We, my lord, consider the recommendation to some extent. Compulsory retirement, we done it. Recovery so far, we not done it. That is. So as per their condition, my lord, the entire recommendation is not considered.
Which is the relevant paragraph that you want to read?
Para 12, my lord.
Para 12.
12. Page number 15 ನಲ್ಲಿ, as rightly pointed out. As rightly pointed out by the first respondent under the Lokayukta Act, the Upalokayukta has appointed an inquiry officer to conduct the inquiry, and after receipt of the report from the inquiry officer, he shall refer the matter to the disciplinary authority to take action. But the Upalokayukta has no power to sit in judgment over the report of the inquiry officer. The recommendation made by the Upalokayukta to impose penalty is bad in law and not sustainable in law. Based on the such legal position, if the learned single judge has come to the conclusion that the recommendation of Upalokayukta to impose a penalty on the first respondent is bad in law, in this case, the disciplinary authority imposes the punishment on the respondent solely on the relying upon the recommendation made by the Upalokayukta. My lord, the impugned order may kindly be seen, my lord. Order of, my lord, compulsory retirement, page number 105. My lord, idರಲ್ಲಿ kindly see, my lord, from they extracted the, my lord, recommendation of the Upalokayukta at page number 105. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ ಅನ್ವಯ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಗಳಾಗಿರುವ ಮುಲ್ಲಾ ಹಿಂದಿನ ಮುಖ್ಯಾಧಿಕಾರಿ ಹಾಲಿ ನಿವೃತ್ತ ಮತ್ತು ಅಮರೇಶ್ ಹಿರಿಯ ಏನ್ ಹಿರಿಯ ಲೋಕಾಯುಕ್ತ ಅಭಿಯಂತಕರು ಪುರಸಭೆ ಮಾನ್ವಿ ರಾಯಚೂರು ಜಿಲ್ಲಾ ಇವರಿಗೆ ಇಲಾಖಾ ವಿಚಾರಣೆ ವರದಿ ಮತ್ತು ಉಪಲೋಕಾಯುಕ್ತರ ಶಿಫಾರಸ್ಸಿನೊಂದಿಗೆ 2ನೇ ಕಾರಣ ನೋಟಿಸ್ ಅನ್ನು ದಿನಾಂಕದಂದು ನೀಡಲಾಗಿತ್ತು. 2ನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸಿಗೆ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 5 ಅಂಬರೀಷ ಹಿರಿಯ ಅಭಿಯಂತಕರು ಪುರಸಭೆ ಮಾನ್ವಿ ಇವರ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅವರು ನೀಡಿರುವ ಹೇಳಿಕೆಯಲ್ಲಿ ಅವರ ವಿರುದ್ಧ ಆರೋಪ ಕುರಿತು ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರು ನಡೆಸಿದ ಇಲಾಖಾ ವಿಚಾರಣೆ ನಿಯಮಾನುಸಾರ ನಡೆದಿರುವುದಿಲ್ಲವೆಂದು ಅವರ ವಿರುದ್ಧ ಆರೋಪಗಳು ಅಲ್ಲಗಳೆದಿರುತ್ತಾರೆ ಮತ್ತು ವಿರುದ್ಧ ದಂಡನೆ ವಿಧಿಸಿರುವುದನ್ನು ಕೈಬಿಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಆದರೆ ಅವರ ವಿರುದ್ಧ ದಂಡನೆಯ ಕೈಬಿಡುವಂತಹ ಸಮಂಜಸವಾದ ಯಾವುದೇ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಅವರ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿಲ್ಲ. ಆದ್ದರಿಂದ ಅವರ ಕೋರಿಕೆಯ ಪರಿಗಣಿಸಿ ಅವರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮವನ್ನು ಕೈಬಿಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಈ ಪ್ರಕರಣದ 2ನೇ ಆರೋಪಿಗಳಾದ ಮುಲ್ಲಾ ಮತ್ತು ನಿವೃತ್ತ ಮುಖ್ಯಾಧಿಕಾರಿ
ಅವ್ರದ್ದು ಅಷ್ಟೇ ಸೇಮ್.
ಸೇಮ್.
What is wrong? You see, therefore, they have simply not imposed the punishment because there is a recommendation by the Upalokayukta. ಆ ತರದ್ದು ಏನು ಇಲ್ವೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದೆ ಮೇಡಮ್.
ಎಲ್ಲಿದೆ?
You
read it out just now. You read it out just now.
ಅಲ್ಲ, ಮೇಲೆ ಅವರು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾರ ಮೇಲ್ಗಡೆ
ಇರ್ಬೋದು, ಅವ್ರು ಹೇಳಿರ್ಬೋದು. ಬಟ್ the final orders are not passed based on the recommendation of the Upalokayukta.
ಮುಂದೆ ನೋಡಿ ಮೇಡಮ್, ಕೆಳಗಡೆ ಇನ್ನೊಂದು ಪ್ಯಾರ ಇದೆ
ನೋಡಿ, ಓದಿ.
ಕ್ರಮ ಕೈಬಿಡಲು ಪರಿಗಣಿಸುವಂತ ಅಂಶಗಳು ದಾಖಲೆಗಳಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಮುಲ್ಲಾ ಹಿಂದಿನ ಮುಖ್ಯಾಧಿಕಾರಿ ಹಾಲಿ 2ನೇ ಸೇವೆಯಿಂದ ನಿವೃತ್ತರಾಗಿರುವುದರಿಂದ ಅವರಿಗೆ ಸೂಕ್ತ ದಂಡನೆ ವಿಧಿಸಲು KCSR ಅನ್ವಯ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಸಹಮತಿ ಪಡೆದು ಪ್ರತ್ಯೇಕವಾಗಿ ದಂಡನೆ ವಿಧಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 7 ಸರ್ಕಾರ ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಆಯೋಗದ ಸಹಮತಿ ಕೋರಿ ಪತ್ರ ಬರೆಯಲಾಗಿದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ 1ನೇ ಆರೋಪಿಯಾಗಿರುವ ಶ್ರೀ ಅಮರೇಶ ಹಿರಿಯ ಅಭಿಯಂತಕರು ಪುರಸಭೆ ಮಾನ್ವಿ ರಾಯಚೂರು ಇವರು KCSR CCA ರೂಲ್ಸ್ ಅನ್ವಯ ಸೇವೆಯಿಂದ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿಗೊಳಿಸಲು ದಂಡನೆ ವಿಧಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡಂತಹ ಆದೇಶ.
Correct. They have not gone by the recommendation of the Upalokayukta. No, he may have made that recommendation. It is based on their independent decision. It's an independent decision.
Independent decision ಏನು ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ my lord. My respectful submission is this.
Sir, you have read it out now. Have they said we are passing this order on the recommendation of the Lokayukta? No,
That's what, my lord, what they have earlier, what Lokayukta has suggested, that has been, my lord, imposed.
no, sir, no, sir.
That has been imposed, my lord. I have been
No, no.
compulsory retirement ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವು ಇವಾಗ 3 ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿದ್ರಿ, 3 ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಕೂಡ ಉಪಲೋಕಾಯುಕ್ತವ್ರು ಹಿಂಗ್ ಹೇಳಿದಾರೆ, ಆದ್ರಿಂದ ನಾವು ಹಿಂಗ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿದೆ, ಎಲ್ಲೂ ಇಲ್ಲ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ದಯವಿಟ್ಟು ಒಂದೇ ಸಬ್ಮಿಷನ್, my lord. ಅದೇ
That is only a reference to the recommendation, but ultimately decision is not taken only in view of the recommendation made by the Upalokayukta. Not so.
My lord, my submission is this, my lord. But even, my lord, the recommendation cannot be made as per the judgment of this honorable court. ಅಲ್ಲ,
ಅವ್ರೇನೋ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ, ರೆಕಮೆಂಡೇಶನ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ರು.
You are right if you say they have passed this order only based on the recommendation of the Upalokayukta. There is no independent consideration. That is not so.
On the last occasion, this honorable court directed them to produce a
That
report.
is what the learned single judge also noticed. It may be true that there is a recommendation, but the final decision is taken by the competent authority independently.
Again, my lord, your lordship may kindly see the order sheet of this honorable court, my lord, 25-9. Order sheet ಹೇಳ್ತಾವ, ದಯವಿಟ್ಟು ನೋಡಿ. The learned counsel so and so by order that passed in WP number so and so, in case number so and so, the Karnataka Power Transmission Corporation
does not have the power to recommend imposition of any particular punishment. ಅದೇ ನೀವು ಇವಾಗ ಓದಿದ್ದು.
ಅಲ್ಲ, ಅದನ್ನೇ ಆಯ್ತು. ಕೆಳಗಡೆ ಲಾಸ್ಟ್ pursuant to the order passed by the government number so and so, it is noted.
All right, you come prepared to counter this one.
Please.
At the request of the learned counsel for the appellant, relist this matter. Can we have it on 14th? Huh?
ಅವ್ರು ಬರ್ತಾರೆ ಎಲ್ಲ, ಮತ್ತೆ ಅವ್ರ ಟೈಮ್ ಕೇಳಿ.
14th.
ಆಗ್ಬೋದು ಅವರು.
Yes.
Please.
14th of November. Yes.
Seal number 37, K. Ravishankar.
Here for the response.
There is a
Principal district judge.
There is some connectivity issue from the morning itself, but I am not able to see any videos. There is some connectivity issue at the High Court of Karnataka.
Release this matter.
Yeah, whenever your lordship pleases. Whenever your lordship pleases, I'll be ready. I'm ready in the matter.
ನೀವ್ ಹಿಂಗೆಲ್ಲ ಬರೀ BCL ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಆಗೋದಿಲ್ಲ ಸರ್.
Sir, sorry, sir.
ಅದು ಇದು ಅಂತ ಹೇಳಿದ್ರೆ ನಾವೇನ್ ಮಾಡಬೇಕು?
Previous dates order sheet which is called out, my lord, in the cost list.
Same thing,
My lord, there was a direction that it will be dismissed for default today if it does not appear. It is mentioned, my
No,
lord.
argue, I'll undertake to.
It is mentioned in the cause list, my lord. Order dated 14/10/2024.
The petitioner seems to be aggrieved of a promotion given to her.
Yes.
From the post of process server to second division assistant.
Yes.
The last may have it tomorrow, I shall not.
You will have to appear here in person.
Yes, yes.
Please don't try to do it on VC. Now,
No.
connectivity sari illa adilla illa aballa. We are not prepared to hear all that.
Oh,
you want to come tomorrow or day after tomorrow?
Even my health is not permitting. My health is also not permitting.
What should we do now?
Last may have it tomorrow, I shall argue through VC.
Through VC
Let it not be a default from my side. Let it not be default or embarrass the court, my lord. I will not. I will not,
Release this matter on 13th of November, day after tomorrow.
please, very well.
Seal number 38, K. Kalaburagi.
Your Lordship, this appeal is preferred by wife, Your Lordship, and respondent is the husband. He filed a divorce petition. The notice was not served upon the appellant, Your Lordship, and the Honorable Court decreed the his petition, Your Lordship.
8th of November 2023. The order was passed.
Yes, Your Lordship.
Huh?
November. Yes, Your Lordship.
Adalva.
8th November.
8th November.
Yes, sir.
Decree of divorce is granted, huh?
Not mine. Response is granted.
Maybe,
Ade.
maybe taken next week. I will get the instructions. Is there any possibility?
Notice was not served upon me.
2nd of January 2024, you have filed the
appeal.
Beyond the period.
Yes, Your Lordship. I was
8th of November 2023. 2nd of January. Within time, huh?
Within time.
It's filed within time.
Within time it's.
I was come to.
In time. In time ಅಂತ ಹಾಕಿದ್ದಾರೆ.
If it is family court, not 30 days. If it is family court, 30 days. If the senior civil judge ballots, it's 90 days. It's as if considered as a regular MF. It is family court, 30 days.
ರೆಸ್ಪಾಂಟ್ ಇಂದ ನಮ್ಮ ರಿಲೇಟಿವ್ ಒಂದು ವಾಟ್ಸ್ಆಪ್ ಮಾಡ್ತಾನೆ ಸ್ವಾಮಿ ಜಜ್ಮೆಂಟ್ದು. ಅವಾಗ ನಮ್ಮ ಗಮನಕ್ಕೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ. ಅವಾಗ ಇಮಿಡಿಯೇಟ್ ಪ್ರಿಫರ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ಇಟ್.
ಟೈಮ್ ಅಂತ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಇನ್ ಟೈಮ್
ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ why is it coming now?
For admission.
Admission ಸ್ವಾಮಿ.
ಸ್ಟೇ ಆಗಿದೆ ಅಂತಂತಾರೆ. Or stayed until further orders. So you want the matter to be remanded?
Yes, Your Lordship.
Ex parte order anta.
Yes, Your Lordship.
But that is why it may be taken next week or not. I will get the instructions and make submission.
Since the appellant is contending that an ex parte order has been passed by the trial court. Common learned counsel for the respondent is directed to secure instructions and make submissions. Stop. Release this matter on 19th of November.
Seal number 39, Baburao Mangane, Shuk Mulage. Criminal appeal.
Yes.
Suspension of sentence.
Suspension of sentence. Earlier occasion, I have argued as far as the sentence is concerned, only 7 years imprisonment is there. Already more than 50% of the sentence they have served. On that ground, I have submitted
1 year imprisonment.
Malats.
You know?
One of the apex court judgment also I have produced. What has directed the government advocate what as far as the convicted the appellants number 1 to 7 for 302 and other offences, and the 1 to 3 have been sentenced to imprisonment for a period of life. As far as appellant number 4 to 7 are concerned, they have sentenced for a period of only 7 years. Already the appellant number 5, 6, 7 are in judicial custody more than half of the period, more than 3.5 years. On that ground,
This appeal has been preferred only.
No, all the appellant's appeal is prepared, but sentence suspension is filed as far as appellant number 4 to 7 are concerned.
Out matra.
Matra.
That
7
application-
years iddavರಿಗೆ ಮಾತ್ರ ಹಾಕಿತ್ತು.
Yes, what do you say?
My lord, it's may take.
The application is filed only by those
Yes, my lord.
accused person.
Yes, my lord. I do agree. But it may take more than half an hour, my lords, if once we start. More than half an hour, I need to argue the matter because the judgment has to be read out. And what the contention that has been taken by the session judge while passing this judgment, my lords, it comes under 302 of IPC.
Howdri,
Yes, my lords.
with all that, if the court has only imposed 7 years,
No, that my submission would be, my lords, the judgment itself is wrong. It has to be.
we are not considering your appeal, sir. Yardidu appeal idu?
An enhancement appeal ಇವ್ರದ್ದು ಅವ್ರ accused
I have filed for enhancement. No, no, I am complaint.
Complainant, yes.
Complaint.
Yes.
ಅದೇ ಅದು recent decision ಇದೆಯಲ್ಲ.
Enhancement.
Such an appeal is not maintainable. Only in certain circumstances.
Yes, I'll submit all the material, my lords.
ನೀವು ಹಾಕಿಲ್ಲ ಇದುವರೆಗೂ.
ಅದರದಲ್ಲ sir, as far as suspense of sentence is concerned.
ಹಾ.
Kindly let me post a habit on.
Objections file
ಮಾಡಿದ್ದೀನಿ sir. ಮಾಡಿದ್ದೀನಿ.
ಹಾ.
Objection has been filed, my lords.
ಹಾ.
And some FIRs are to be submitted before the court, which have been registered against these appellants prior to this occasion, my lords. That is in section 479 of BNS, what it says, if the person is not involved in any another case, then only that particular benefit is to be given.
It may not be of any help if you are pointing out to some case that was registered prior to this judgment.
Yes, my lords.
Adalla.
That is there in the section itself, my lords. I'll submit. Hold in 436A CRPC, that is there. No, no, no. Retrospective, I am not submitting that, my lords. Let's have it on next week, my lords. I'll argue. Final.
And he is saying they have served more than 50% of the term already.
That is before the passing the order, my lords. When they were in judicial custody, when they were being tried, my lords, by that time only, for bail purpose. Now they have been what? 302. So the order, the conviction order has been passed, my lords.
Sentence is only for 7 years.
That is there, my lords. My submission would be sentence is totally wrong. It has to be reversed.
While considering this application, that submission cannot be considered.
Yes, my lords. I'll give that particular aspect and material. I have it on next. On 19th it would be. 19th also.
The request of the learned additional SPP, release this matter on 19th of November.
Please.
Yes.
Ramachandra ke.
My lord, in this case, last date of hearing, I was directed to take notice. Copies have not yet been served on me, my lord.
Copies are not served.
Not served.
Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel Sri Kripa Sagar Patil.
Please. Correspond number 2 to 4.
Release this matter on 21st of November.
Please.
Seal number 41, Rajesh Doddamani. 41.
There is no representation for either of the parties. Release this matter on 22nd of November.
Seal number 42, Shanabasappa, M. Patil.
My lords, appearing for appellant, my lord, this is insurance appeal, my lord, challenging liability and quantum both, my lords. Charge sheet is also filed against the. No.
No delay.
No delay, my lord. No.
Huh?
No, my lord. Within limitation.
I am for a KV respondents, my lord. It's a death case, my lord. Withdrawal permission may be given, my lord.
Huh?
It's a death case, my lord. I am for.
Are you challenging
Liability, my lord. Yes, my lord. Abated charge sheet has been filed against the deceased, my lord. You are, and in opposite direction, accident has occurred.
Learned counsel, Srimati Shanta Bai Patil.
Yes, ma'am.
Has entered appearance for response number 1 and 2.
Yes, ma'am.
What about 3?
Three is the, my lord,
owner come driver.
yes, my lord. And against
Issue
the,
notice to respond number 3. Huh?
yes.
You got copies of the appeal memo?
No, my lord.
I have served.
No, sir, sorry, my lord,
Ah.
sir.
You filed the execution case?
Yes, my lord. But they have not yet deposited. If deposit may be made before
An
tribunal.
interim order of stay of the impugned judgment and award in MBC 165 of 2021 on the file of the MACT, Sindhunur, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today. Yes.
Withdrawal permission may be given.
Our liability ಇದು ಮಾಡ್ತದಾರಮ್ಮ ಹೆಂಗ್ ಕೊಡಕ್ ಬರುತ್ತೆ? Let us.
B group matter?
B group ಬೇಡ. 43.
Serial number 43, your lordships have heard this matter and particularly today is the date is the given.
ಏನಿದು?
But it's relating to the recruitment of the primary school teachers concerned, wherein the learned lords, the Jaikumar S. Patil's senior counsel has appeared. That your lordships have specifically lords observed in the order, in the interim order, and to verify that whether the
ಎರಡ್ ಸರಿ ಹೇಳಿದ್ವಿ ನಾವು AAG ಅವರಿಗೆ.
ಅದಕ್ಕೆ it may be taken on 14th, my lord, since the senior also will appear on 14th.
They make one submission. Make one sub. Matter see my lord. VC matter rest number my lord.
14th, I request. Even there is a one constitutional bench judgment, my lords, delivered on 7/11/2024. These aspects were considered. The change of the rules once the game is begun, that is impermissible. And specifically, the Supreme Court has held that since when the notification is issued in the midway, they cannot be changed in the recruitment process.
At the request of learned counsel for the petitioners. Release this matter on 14th of November 2024. Full stop. The learned AAG was also requested earlier twice to secure instructions and make submissions.